encouragement in strengthening the IP ecosystem in India, particularly among students, professional, and emerging innovators. On behalf of IPTSE, we extend our heartfelt gratitude to Ericsson for being a valued and enduring partner in this journey. We sincerely thank Gujarat Council for Science and Technology, Guj Cost, and the Center for Entrepreneurship Development, Government of Gujarat, for their valuable support in facilitating registration of startups, faculty members, and affiliated students for the IPR examinations conducted by IPTSE. I also take this opportunity to express our sincere appreciation to AAFT for extending its support to the conclave and for encouraging participation of students and faculty members from its affiliated institutions. To formally set the context for today's conclave, may I invite Ms. Hiteshi Trivedi, Director, IPTSE, to deliver the introductory remarks and share the vision behind the 8th edition IPTSE.
Ladies and gentlemen, dignitaries on the dais and off the dais, distinguished guests, esteemed participants, students of IPTSE, rank holders, a very good evening. I welcome you all at the 8th edition IPTSE Awards and IP Conclave. As you're all aware, IPTSE, or Intellectual Property Talent Search Examination, is an IP talent search exam conducted pan-India that tests the knowledge of an individual on patents, designs, trademarks, copyright, geographical indications. All our past editions have received support from state and private universities and government institutions to further the IP knowledge in the country. The exam is customized from different domains like law with IP specialization, law without IP, hospitality industry, research and science, design and architecture, etc. We are happy to share that this edition we have introduced a new domain, pharmaceuticals and IPR, and we have received an overwhelming response through registrations in this domain. The various editions of IPTSE have been supported by several organizations that believe in knowledge-based economy such as METI, MSME, AICT, NRDC, CPAM, AICT, etc. Just to share some statistics on the impact factor that the initiative has been able to make. We've conducted across 400 plus IP awareness programs, pan-India. Total sign-ups for various editions have reached almost 60K, and approximately 35,000 students have done the exam registrations over these years. We have around 80 plus MOUs signed with several educational institutions across pan-India. Around 300 plus videos which are uploaded on our channel of IPTSE, YouTube channel, and approximately 1,000 IP-related content on various social media channels of IPTSE. In our endeavor to proliferate participation of young minds to take IP examinations and its benefits, we have been upgrading the level of examination. We've also been conducting exclusive webinars for our registrants on various course-related topics and on current IP-related topics. We are happy to share that this edition we have it'll be a continuous exercise of IPTSE to thrive for excellence in the field of IP. I'm also pleased to announce that year on year we have been receiving greater participation from various regions across the nation, and it has received increased presence nationwide. We are also happy to share that with the GI event in Gandhinagar, which was conducted in April, we were happy to have promoted the GI tag artisans in the event. The theme for the 8th edition this year is IP for sharing, promoting collaborative innovation. Today's theme resonates deeply with the challenges and opportunities of our time. Intellectual property is not merely a legal tool, it is a dynamic force that fuels creativity, drives innovation, and creates pathways for sustainable growth across industries. At the heart of this conclave lies a commitment to fostering an ecosystem where IP is leveraged not only for a competitive advantage, but also for inclusive growth. As we embark on today's journey, we'll hear from visionary leaders, industry pioneers, and domain experts who will share their insights into the evolving landscape of global trade, the strategic value of IP, the role of industry, academia partnerships in driving innovation, Later during the day, we will also celebrate and felicitate the 8th edition winners. Let us make the most of this platform to exchange ideas, forge collaborations, and a chart to pathway a future where IP serves as a powerful tool for economic empowerment and sustainable growth. Thank you once again, and welcome to the 8th edition of the IPTSE Awards and IP Conclave. Thank you.
Thank you, Ms. Trivedi, for outlining the journey and growing impact of IPTSE as a unique national platform for nurturing IP awareness and talent. Our next speaker brings a strong global industry perspective on intellectual property and innovation ecosystem. It is my privilege to invite Mr. Patrick Hopkins, Head of IPR Policy at Ericsson, to deliver the theme address on IP for sharing and collaborative innovation.
Thank you. Good afternoon or good evening, distinguished guests on the dais and off the dais, and a special welcome to our guest of honor, Dr. Raghvendra, Senior Consultant at DPIIT, the Ministry of Commerce and Industry. It's really a pleasure to be here today at the 8th edition of IPTSE Conclave and IPTSE Awards. And I would like to congratulate IPTSE for creating such a platform that brings together so many different stakeholders from different spectrums and different parts of life. And on behalf of Ericsson, I would like to extend a very sincere and warm congratulations to all the IPTSE Award winners that we will honor later this evening. So allow me to briefly introduce the theme of the conclave, intellectual property for sharing and collaborative innovation. And I would first like to zoom in on the collaboration aspect. At a moment when technology cycles are shortening and innovation is becoming more and more distributed, solutions very often demand cross-border cooperation. Indeed, global innovation is very collaborative today, and let me illustrate this with a couple of numbers. The first number is 90%. 90%, according to global IP trends, over 90% of today's digital technology relies in one way or the other on technical standards that are built by thousands of engineers contributing across many companies, universities, and research institutes across the world, 90%. The second number is 33%. More than 1/3 of all patent filing today in the world involve some form of international collaboration, and it shows that innovation has crossed national and institutional boundaries and is truly global. Thirdly, across academia and industry, we see more and more public-private research partnerships engaged in open access research in which stakeholders can participate from different regions. The inventions that are the result of such research are then very often leading to collaborative licensing that then ends up having that research result in products and services that are available for consumers worldwide. These different collaborative models are possible and can only work because they're supported by a very strong IP right. Without predictable and trusted IP frameworks, this global collaboration is simply not possible. And India's role in this global innovation ecosystem is expanding rapidly, and the data confirms it. Last time at the 7th IPTSE Award ceremony, I presented some numbers on growth and IPR results in India. And for this edition, I've asked IPTSE to help me updating the numbers, and the numbers are staggering. The growth continues. So year on year, there's a 20% growth in overall IPR filings, arriving at 7.5 lakh filings for 2025, including 75,000 patents, and patents for 61% filed by Indian applicants. On trademarks, the numbers are also staggering. 5.3 lakh of trademarks filing, and copyright crossed the 40,000 mark. So numbers of growth that are really impressive year after year. What is also notable is that Indian startups today file patents not only domestically in India, but also across US, Europe, and Asia, signaling global ambition and also cross-border collaboration. And then there are the government initiatives that was already referred to before. These initiatives are really important, and I can name some: Startup India, Digital India, and the National IPR policy, which all have significantly improved awareness of IP. And it starts with awareness, of course. Awareness of IP helps them further creating a strong IP framework where processing speeds have improved and enforcement mechanisms are worked on day after day. The second aspect of the conference is the IP for sharing, and that topic may sound a little bit strange as people very often relate IP to exclusion and monopolies, but allow me to counter that by giving you some concrete examples. And the example I would like to give you, and I know a little bit of, is the standardization, technical standardization. Technical standards like Wi-Fi, 4G, 5G that we use every day. They are technical developments created in the standardization context. And so how it works is that these standards are created by different inventors from different companies in universities and research centers coming together and basically creating new technology. 4G, 5G, Wi-Fi are new technologies created in the standardization process. And they do that by basically coming together and sharing ideas during the standardization effort. So they come with the inventions that they have created in their companies. These are proprietary owned inventions. They verify and they compare these inventions with each other. And to do that, they need to protect these inventions. If you don't protect an invention, then it's lost, of course. So the IP is used to protect the invention, to then be able to compare it with each other and to decide what invention is the best to go into the standard. In the second phase, once that standard is created and the inventions are in part of that standard, the IP is used to share the standard technology with companies and individuals that have not participated in the creation. So even companies and individuals that have not helped creating the standards will later on, thanks to licensing of IP, be able to use the standardized technology in products and services worldwide. And so even if they're not contributing, even if they're competing with those who've created the standard, they are able to use it thanks to IP. So IP in the standardization context really helps to share. And it's therefore very encouraging to see that India's growing engagement with standards is reflected in more and more innovation based on standards, more and more startups using the standards to innovate on top and using the standardized technology, and also an ambition to move from being a standard taker to a standard creator, with an ambition, for instance, on 6G for India to become an important co-creator of global standards. I think that requires a couple of things, and amongst others, the first is a strong IP framework. That IP, as I said, helps people to work together, helps people to share ideas, and getting a return on investment for these ideas. Second element that is really important is good awareness of IP. And this program, organized by IPTSE, helps focusing on that awareness, focusing on education of youth in IP. The third point is, of course, knowledge of standardization. Standards come in very many different shapes and forms. You have mandatory standards, voluntary standards, different technologies. For instance, AI will probably also be standardized to a certain level. Quantum technology is standardized. So many different forms, many different shapes, many different business models, many different types of IP supporting standards. And it's important to deepen the knowledge about that standardization, deepen it by governments, by industries, by research institutes, and by universities, to recognize the differences and to continuously improve the standardization environment. India today stands at the intersection of unprecedented digital creativity at an unprecedented scale, with over 2 million active content creators and one of the world's highest mobile data consumption rates. Creativity in India is no longer confined to the studios or publishing houses. It's really live, it's mobile, it's collaborative, and it's instant. It's everywhere. But at the same time, that scale makes the creators vulnerable, because copyright infringement, unauthorized reposting, and misuse of creative worlds travels at the same speed as the innovation travels. So in this environment, intellectual property protection is not just a legal safeguard, it's really an essential economic infrastructure for India's growing digital economy, which already contributes more than 10% of national GDP. The second panel of the conclave today is then also very relevant because it will elaborate on protecting creativity in the digital age through IP. And conferences like this are a really valuable tool to demystify IP, showing that it's not really a legal hurdle, but it's really a strategic enabler of innovation and collaboration. And the challenge before us is to strike the right balance, and balance is a super important word that we use in Ericsson all the time. Balance between protecting creators, but at the same time encouraging collaboration. Balance between enabling sharing, whilst also ensuring a fair return for those who have created. If India can build digital public infrastructure at a large scale, it must also be able to build a trust infrastructure for creativity where ideas can travel freely, but the rights to protect these ideas travel with them. And let me then also conclude with this thought that innovation thrives where ideas can move across institutions, industry and borders, but creativity endures only when creators are assured of recognition and a fair reward. In India's rapidly expanding digital ecosystem, IP must therefore function not just as a legal framework, but really as a trust framework. I congratulate IPTSE on this 8th successful edition, and I would like to thank you all for the opportunity to share these perspectives. Thank you very much. Thank you.
Thank you, Mr. Hopkins, for that insightful address highlighting how IP can act a bridge between technology, collaboration, and sustainable innovation. We now move to a very important segment of today's program, which is the expert remarks. It is my privilege to invite Dr. G.R. Raghvendra, Senior Consultant, IPR, DPIIT, Government of India, to share his expert perspectives with us today. Dr. Raghvendra has played a pivotal role in strengthening India's national IP ecosystem, particularly through policy advisory, institutional capacity building, and implementation support under flagship initiative of DPIIT. His works has been instrumental in promoting IP awareness, commercialization of innovation, and integration of IPR with startups, MSMEs, academia, and industry. We are honored to have him with us as a guest of honor, and we look forward to his insightful expert remarks on evolving role of IPR in India's innovation-led development. May I now request Dr. G.R. Raghvendra to kindly address the audience.
Vande Mataram. Good afternoon to all of you. My friend Patrick Hopkins, Head IP Policy, Ericsson from Brussels, and Hitachi and her colleague, Ms. Trivedi, and my friend Sheetal, and all the dignitaries, especially the winners of IPTSE 8th round. I'm so happy to see that young minds are very, very dynamic and showing interest in the IP ecosystem, how it works, and how to spread the awareness. The theme is IP for sharing, promoting, innovativeness. It's very important because Government of India recognized this while drafting the National IP Policy, which was released in 2016. The very motto of the IP policy, National IP Policy, is Creative India and Innovative India. So the promoting collaborative innovation is the key pillar for the National IP Policy, and the Government of India has been doing this. When Startup India was launched, and the Make in India, it all started with the Make in India. Honorable Prime Minister inviting the world manufacturers come to India and make in India. There was a need for promoting startups, not only inviting the manufacturer from abroad, encouraging young brains like you to go and venture, become entrepreneur with the startups. Now, when Startup India was launched in 2015, and the Indian ranking was insignificant. Now India has the third largest startup ecosystem, more than 1,90,000 startups, nearly 48% of startups to uh, contributed by women. So that is very encouraging to see that. And 111 unicorns are there, and more than 5 decacorns are there, like Flipkart, Nika, you all know those. And ecosystem is growing because government promotion uh, of expediting in the examination of their patent filing, trademark filing, and other IPs, support given to them, especially the SIPP, scheme for intellectual property promotion for the startups, has created a lot of interesting avenues for them to get IP protection. And another scheme is IP Mitras. So a panel of IP specialists helping these startups, and government funding the fee meant for that. So startups have to pay only the application fee for the patent, trademark, design, copyright. So rest of the legal work done by the IP agents, like patent agent, the trademark agent, or IP lawyers. So government is funding the payment in the terms of fee and etc. The most important thing in the national IP policy is that IP for sharing. That's what it says, and promoting the collaborative innovation, the licensing mechanisms, and also the commercialization aspects. And IP awareness aspect, government has set up a special cell called Cell for Promotion of Intellectual Property Awareness and Management, CPAM. This has been working excellent manner, and it has been organizing a lot of awareness programs, not only for the enforcement authorities, which includes the customs departments, various universities, various stakeholders, and this has created a lot of interesting avenues for IP-based entrepreneurship in India. If you see the India's ranking, which my friend Patrick was referring to about the India's IP ecosystem, if you see the India's ranking in 2014, the Global Innovation Index, the ranking brought out by WIPO Geneva every year. 2014, India's ranking was somewhere 81. Now 2025 report, India stands at 38. So look at the kind of jump happened. It's because of young minds, those who take this kind of talent search exam, and tomorrow they might become innovators, are the key players in filing patent applications, or trademark, or design, other IP protection exercise which they are doing. Look at the standing which India has today. Because 20 years back, I was just pledging at the beach of IP ecosystem. I was new at the time. My peers used to tell me that patent office is for only foreign filings. 80% foreign applications, 20% Indian application. Oh, it was an education to me. Look at the system now. It has completely changed scenario. India's rank in patent is 6th rank in the world patent filing. Most of the filings, Indian filings have overtaken the foreign filings. Trademark India, now it is the 4th rank in the trademark, and design 8th rank in the in the design system. Of course, you know that copyright filing is not mandatory. Copyright is automatic, but the kind of work we are doing, the Indians are doing, is very encouraging. And if you know this another information, Jyotiraditya India, the Minister for Telecommunications, for the 6G technologies, he set a benchmark for India to be one of the top 10 countries by 2030. Forget about the Vikasit Bharat. We have very ambitious targets for Vikasit Bharat. When India becomes a developed country, that's what we are trying to become by the time India going to celebrate its 100th years independence in 2047. And now after 75 years in independence, we call this Amrit Kal. That is the name given by Prime Minister, in which everyone has to contribute, especially the kids who have won the awards. They should take the lead to improve the uh, IP ecosystem by remove the gaps or remove the maladies in this system. That's what government is continuously trying to remove these kind of maladies. One of the greatest areas which we need to work upon, the SEP policy guidelines, which Patrick has been successful removing the wrong policy step taken in the EU in this regard, especially the SEP regulations. And India should have such regulations so that the any SEP hold up happening or any other wrong, because one has to respect the IP first. So voluntary licensing is whether it is a FRAN licensing. So the terms have to be respected by the both sides. That is the step. And you see the recently India has revised its patent rules, published the revised patent rules in 2024. That is a one step ahead, promoting collaborative innovation. Next came, now we are considering trademark amendments. We have completed stakeholder discussion, multiple stakeholder discussions, and soon that will walk its way to the cabinet approval and the introduction in the parliament, hopefully in the next session. And another area we're working seriously is design area. Design is one of the weakest laws in the entire Indian IP ecosystem. In trademark, we are looking future, like unconventional marks. Protection of unconventional mark is the area we have concentrated, and also removing the delays in registration. And despite giving, because everyone cannot go for expedited examination, and delays do happen, reducing the delays is important. Then the trademark, and also design, the graphic user interface. Lot of digital designs are coming, AI based designs are coming. These are the areas we are concentrating, and also make India to join Hague system, the Geneva Act of 1999 Hague system, which facilitates international filing of design application, which we have Patent Cooperation Treaty, PCT, international phase for the patent international application. We have Madrid protocol, international application protection of the trademark. We don't have such system for the design. India need to join that. India actively participated in finalizing Riyadh World Design Law Treaty, which is mostly the procedural aspects. We have patent law treaty and the procedural aspect. We have Singapore trademark treaty, again trademark procedural aspects. Now the third one, the latest WIPO treaty is Riyadh treaty now for the design. So Indian team participated actively, and we need to include those things like grace period, deferred publication, and all that in interest of promoting the designs. Similarly, geographical indications, which Patrick and Tanshi was mentioning, and here we don't have a policy. Like a state like Karnataka has a GI policy, geographical indications policy. So we are considering a national policy on geographical indications. The famous slogan given by Prime Minister, that vocal for local, from local to global. That's what we need to implement for GIs. So we have to make them Not only the Darjeeling teas or Pashmina shawls, we have the Alfonso mango or Goa feni, Kanchipuram sari or Banaras silk. So there are, my registry told me recently they have crossed 790 registrations nearly. So minister has given the target of 10,000 registrations by 2030. So we need to achieve. So government of India started a scheme called One District, One Product. You know, each district has to promote one product so that vocal for local, local to global. So all ODOP, one district, one product, ODOP may not be GIs, but all GIs are ODOPs. So it is for the younger generation to encourage your friends and everyone, the colleagues, to identify geographical indications and make them register those first form the association of producers and manufacturers of those GI and make them register so that they will be protecting their GI and then giving a boost to their livelihood and also contributing to of IP to the GDP of the country. Despite Trumpanian 50% tariffs, India has grown tremendously in the last uh, term. Last 3 months, economy has grown 8.4% GDP, unprecedented, despite 50% tariff increase. And then even our exports have grown. That's the record. Uh, and many countries have shown interest an Indian product. Now after Operation Blue Star, there is a big queue outside the Defense Ministry buying our BrahMos and other indigenously made defense technologies. So and the DRDO, Defense Research Development Organization, is the leading patent filer, leading R&D, 100% indigenous production. They are doing that. I'm really proud of the product. And every 2 months, you see a big news, Big Bang news, showing that this is the new, development of the missiles. Of course, we have DRDO's ISRO. They are doing magic now. They have become world number one commercial satellite launchers. The kind of success they have. As a kid, we all read about NASA, uh, and kids must be dreaming, must have dreamt to become a NASA scientist, a job in a NASA. Now everyone will dream about job in ISRO. All the scientists, typical traditional, wearing traditional Kanchipuram sari or Mysore silk, they are doing all the R&D there and achieving grand success, and they are the leading patent filers again ISRO. So all this happened, and congratulations to the all leading team of two great ladies sitting here, and also my friend Sheetal, and entire team, encouraging young generation participate in this. That is very important. Making them aware, uh, irrespective of the subject streams you are studying, whether you are a science student, engineering student, IT student, or arts and social sciences like journalism, that is considered of social sciences. Because when I was studying my MA archaeology, my batchmates were there in journalism. Now they are heading the Telangana Today editor, Srinivas Reddy, my batchmate. So they should know what is the importance of copyright, because now AI has come. Recently you must have read a white paper released by my department on AI, generative AI and copyright. This second part is coming. So we have not copied and pasted EU system there. We have thought it differently, and protection of creators, that is the most important. Again, respect to the licensing. The way Erickson thinks about the importance of licensing, that's what we be promoted, the creators' interest, whether it is the patent or copyright that need to be protected. So again, congratulations to IPSTC and also winners. Hopefully we'll be meeting in the next session. And thank you very much for inviting me to give these special remarks. Jai Hind, Jai Bharat.
Thank you, sir, for your valuable insights on strengthening innovation and IP linkage. To formally conclude the inaugural session, may I invite Ms. Purvi Pandey, Director IPTSE, to propose the vote of thanks.
Thank you. Distinguished dignitaries on the dais, respected speakers, esteemed partners, ladies and gentlemen. On behalf of IPTSE, I thank you all for being part of the 8th edition IP Conclave and IPTSE Awards. We are truly honored by the gracious presence of Dr. G.R. Raghavendra, Senior Consultant IPR, DPIIT Government of India, and former Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India, for highlighting the objective of the IP office, the vision with which the IPR policy was developed. And sir, I'm truly looking forward to see Amrit Kal of our Viksit Bharat. Thank you for such an insightful address. We express our deep sense of gratitude to Ericsson, our valued industry partner, for the steadfast support and visionary engagement with IPTSE. We are particularly thankful to Mr. Patrick Hopkins, Head IPR Policy, Ericsson, for his insightful theme address, which aptly sets the tone for today's deliberation on collaboration, innovation through IP, and how IP is protecting the new technology. We gratefully acknowledge the continued engagement and support for our government partners, Gujarat Council of Science and Technology, Good Cost, and Center for Entrepreneurship Development, CED, Government of Gujarat, whose association has been instrumental in fostering participation from students, startups, and emerging innovators across the country for this 8th edition. Thank you. We also extend our warm appreciation to AAFT for joining us as our supporting partner and for actively promoting engagement from the creative and academic community, thereby enriching the multidisciplinary spirit of this conclave. I extend our heartfelt appreciation to all our esteemed speakers, moderators, and panelists whose valuable insights and contributions could make the coming sessions truly enriching. We are thankful to Shri Aman Sharma ji, IPOS Joint Secretary, Department of Pharmaceuticals, Ministry of Chemicals and Fertilizers, Government of India, for accepting our invitation and giving us his consent to be our chief guest for the valedictory session and award ceremony during the day. My sincere appreciation also goes to the entire IPTSE team, our technical partner Default Technologies, collaborating institutions, and all our participants for their unwavering support and faith in this platform, which continues to nurture India's IP talent and innovation ecosystem. Once again, I thank all the dignitaries, partners, and participants for gracing this occasion and for being the integral part of IPTSE journey. Thank you all very much.
Thank you, Ms. Pandey. We now move on to our first panel discussion, IP for sharing, encouraging collaborative innovation through IP, focusing on how India's IP ecosystem supports open innovation, collaborative licensing, and startup-led partnerships. I would like to invite all the panel members and moderators of the panel for continuing the discussion. Inviting Dr. Anil Wali, CEO, BITS Biosynth Foundation. May I May I request Ms. Hiteshi Trivedi to present a token of gesture to our moderator, Dr. Wali. May I request Ms. Purvi Pandey to present a token of gesture to our other panelist, Dr. Yogesh M. Duble, Chief Scientist, Innovation Protection Unit, CSIR, National Institute of Science, Communication and Policy Research. May I now request Ms. Hiteshi Trivedi to present a token of gesture to Dr. Akshay Kant Chaturvedi, RD, R&D, IPR Patents and Trademark, Gujarat Fluorochemicals Limited. May I request Ms. Purvi Pandey to present a token of gesture to Dr. Veena Arora, Head IP Council, SRF Limited. May I now request Ms. Hiteshi Trivedi to present a token of gratitude to Mr. Professor Dr. Manveen Singh, Professor and Associate Dean, Jindal Global Law School. We look forward to a stimulating discussion covering policy frameworks, academic perspectives, and real-world industry experiences. Over to you, Dr. Wali.
Thank you. Namaskar and very good evening. And my sincere thanks to the organizers for giving me the opportunity and one of the opportunities to actually engage with you all. And given the context in which we are speaking and looking at the audience composition, so obviously we will be discussing accordingly. But first of all, my compliments to the previous speakers, particularly Patrick, for giving a beautiful context to the title IP for Sharing, even though it's implicit in the IP world, because at the end of the day, we have to ensure that it reaches or does community good. But I think the good part about this session is that I don't have to speak much. So I leave it, I make it very short and go straight to the business of the day. And well, I think first of all, I'm fascinated by being flanked with experts and obviously junior to me in age and maybe more, but not junior in expertise and knowledge. So I'm very grateful for deciding to participate in this session which I've been asked to moderate. So let me go straight and so what we will do is we will have a quick round of questions, and I would request my members of the panel to be short on answers so that I want to leave some space for the audience, more particularly our younger the participants to ask us some tough questions. Is that fine? Thank you. So let me start with the ladies first. Veena ji. So, Veena ji, I think it was mentioned by Mr. Raghavendra about our new IPR policy. So maybe in that context, when we all, at least excepting me, maybe all of you perhaps are better aware of that. How has this policy actually impacted our collaborations? Because we have been talking about IP sharing, the collaborations, and more particularly the inventive output. And if you are seeing any visible trends in this space.
Thank you, Dr. Wali. And I would like to extend my congratulations to the IPTSE team for this initiative and this 8th conclave. Am I audible? Okay. Is it?
I think this should be. So
Okay. Hello. No, it's fine. Yeah, thank you. So I extend my congratulations to the IPTSE team for organizing this IP conclave and taking this beautiful initiative. And now moving on to the question raised by Dr. Wali. See, for IPR policy, I think Dr. Raghavendra set the stage very nicely for that. He gave us an overview of various IPR policies and what they, how they initiated the collaboration between the academia and the industry. But I would just, before we touch upon how this IPR policy has facilitated this type of these collaboration, I will touch upon the various objectives of this IPR policy. The first very objective was the IP awareness, which is this initiative is one among them. Then second was IP generation, and that is IP generation by academia and startups, various, the grassroots innovators, and the different, research institutes, and of course the different big and small corporations. Now, the third objective which IPR policy set right was the legal and legislative framework, which we do have very good enforcements for IPR generated. The third was administration and management of IPR, and that led to the creation of CPAM, as Dr. Raghavendra also pointed out. And this is a very, it created a platform for different collaborative activities among the various universities and the companies. The third was commercialization of IPR. I would, before I touch upon this, and the sixth one, which is the fifth and sixth one, is enforcement of the and adjudication of the IPR and IP rights. And the last one is the human capital generation development. Now, before I touch upon any of these, the most important for this conclave is, and especially for this panel discussion, is the commercialization of IPR. Though we have various platforms, like we have CII, we have BIRAC, we have NDRC, TIFAC, and different other for cross-licensing of the various innovations which are happening across the different agents. Like we have grassroots innovators, we have different research institutes, we have different academics which are working on the different level for generation of different innovations. But this is the aspect which is very, very important. Now, how this IPR policy has led to the different collaborations. This IPR policy has touched the collaborations between the industry and the academics in 5 different ways. First is the internships. You will see after 2016, after this IPR policy was rolled out, there has been a sea change in the number of internships provided by the different companies. So I have a small data, 20,000 virtual internships in the field of cybersecurity and cloud computing. Then TI, Google, and Microsoft, they also initiated different internships to the industry for the to the different academics and to the research institute people working in the students and the PhD scholars working in these institutes. Then there is another initiative taken was joint curriculum design, which is which is very important. Now what we usually see is there is a difference, there is gap between what is research, what research is going on in the universities, and what we actually see and what we need as a in the commercial setups, like in big companies, big and small companies. So this gap is being filled by the creation of this joint curriculum. And I have few data also which says the Bosch, Cineant and Global Logics, they have created different these type of curriculums, joint curriculum design with BITS Pilani, various IITs, IC Bangalore and others. Third type of collaboration which has
Maybe we
which
can
we
come
have
to
seen.
this subsequent.
Okay, just two of then there is sponsorship innovation also. There is sponsorship ecosystem has been created, and there is consulting projects. But to be very, very frank with you here, what we see is after this IPR policy, there has been there is a movement, but we are taking little baby steps here. I come from an industry which is a pharma and a chemical industry. And in that industry, I see very few collaborations, and the most of the collaboration, the 90% collaboration is concentrated in the expert, knowledge sharing platforms only. There is very little collaboration, whereas some prototype is created between after, collaboration with the industry and the academics. So this is an overview, but I think we are going in the right direction, and in a year or so, we'll see good collaborations happening here.
Thank you. Yogesh, let me come to you. I think given the fact that you are actually managing the entire portfolio of the large establishment called CSI, which is a publicly funded institutions. So in your many years of experience now, how do you see the trends of, let's say, IP protection vis-a-vis actual technology development from this organization?
See, let me.
I think
Okay.
Yeah.
This
is also. So, good evening to all. First, let me give you how the PROs work. PROs are the very silent workers in the science community, and since after independence of the India, there was a very deficit of the science community. So CSIR, there was a fellowship that came in and had given an opportunity to the people to pursue science, and the applied science was a far-sighted thing that no one used to think about the applied science. Then came the applied science, the engineering came in, and then really the people of India were thinking about tech transfer. So the journey, from the very humble journey this year, the India began its journey from the science to the tech transfer, the basic science to the tech transfer. So coming from that level, and now we are seeing the CSIR or the other PROs are working in the niche areas where actually the IPs are respected. So beginning the journey of the IP, and CSIR has also given its immense contribution in giving the CSIR in the news. News and media, like you can see the haldi and turmeric in 1995 or 1998. In those times, they had made a news. So that news has given a very impact that the common people were also knowing that the patents, what is patent, and they were also getting curious about what patent actually hota kya hai. So still there is a notion, but now slowly that as the within the academy also, now it is a curricular IPR is introduced in their curriculum. So now everyone, the students are also now graduated to that level that they know what is patent, copyright, design, and trademark. So from that level we had started, and rightly I will come directly to the CSIR. So CSIR also had a very few patents in their portfolio, and they were also filing many patents here and there from anywhere to say thoughtful IP. So now the CSIR is has come to the thoughtful IP, where CSIR really thinks about starting the collaboration at the initial level of the project itself, so that the IP is filed in a very focused manner, and making a portfolio is a very important thing. It is not that you just file a patent and forget, but to take it to some level, that is TRL level, that is technology readiness level, is also very important. So CSIR or any PRO is having some kind of limitations because of their kind of mandate they are given. So up to certain extent the CSIR can take the technology, that is TRL 3 or 4, but beyond that we need a partner, an industrial partner, which will take up. So now the CSIR has more matured and saying that we will give some kind of projects, and wherein there will be some kind of projects that are called FTC, that is fast track commercialization projects, or of FTT, that is called fast track translation projects, that are of 1 or 2 years, wherein the patents or the bench level has given a very good results, and they are ready to be taken up. So they are given some more boost of money, and they are really taken up to the pilot scale with the industry partner hand in hand, so that the technologies can be matured and see the real production happening, and that is how the industries can get attracted towards CSIR. So with that, with the focused IP portfolio, now CSIR is doing real changes, and right from the, if you can see the hydrogen hydrate plant, it was an indigenous plant which is there, and also the indigenous first time that CSIR has created the paracetamol API. Now that is the first of its, because the paracetamol was earlier imported into India, the API was not there, so reducing import and making the India a real Atmanirbhar Bharat is very important, and CSIR or any other PRO is there to make India a Atmanirbhar Bharat and to achieve the sustainable goals that are given by the United Nations. Good, that, thank you.
Thanks, Yogeshwar. The reason I asked this question was because what Dr. Raghavendra mentioned, of course, he gave two names of ISRO and DRDO. So that's why I was prompted to ask you this particular question with regard to the indigenous technologies. Now, I think taking on from that, and I turn to Dr. Chaturvedi. Dr. Chaturvedi, I think, of course, what is there in the news is the rare earth and stuff like that. Okay, the magnets and all that. I'm really not going into the geopolitics of it, but given the strength, given that you are coming from chemical materials sector, my question to you is, in reality, would an IP portfolio from India suggest any strategic strength that we have?
Thank you very much for IPTSE for giving this opportunity and organizing this session. First of all, I would like to tell about, I think my colleague Dr. Yogesh has mentioned paracetamol was not their API in India, but it was, I think India was the largest manufacturer in the world for the paracetamol. I think CSIR has done a great initiative while working with NCL Pune to develop a technology which is a flow chemistry based process, and it's a continuous process developed, and the technology has been transferred. And I worked in Granules India at Hyderabad, and I remember that we were the largest manufacturer of API of paracetamol, even the granules of that. Before that, there were others also. The first manufacturer was in US basically. So that's just a correction on that front basically, and maybe we can discuss this later on. I think as Dr. Anil has asked about the strength, yes, India has potential strength of innovation, and there are, as Dr. Rajwinder has mentioned, that large number of patent filings are happening since last few years, and if we see the data, it shows that 2024-25, every year more than 1 lakh patent applications have been filed in India. So that shows, the kind of innovation work which is happening, the inventive steps, the inventive merits which are available in India, and if the patent applications are filed to a tune of more than 1 lakh every year since last 2 years, that shows that there is a lot of scientific acumen work is being happening and is being churned out in terms of the commercial inventions basically. And second important front is that, as Dr. Anil has mentioned, that chemical materials, specialty sector, this sector is growing at a very fast pace, and India is among the 6th largest manufacturer for the chemical materials and specialty chemicals in the globe, and in Asia I think we have a position 3rd. So we are doing a lot in the chemicals, materials, specialty, and we are supplying to the globe. We have exports to a tune of $75 billion last year. So that shows that there is a lot of export which is happening for the chemicals basically. And we also import quite a huge amount of chemicals and intermediates and materials from outside. So there is a gap of around $40-45 billion in India worth chemicals which we import from globe basically. And this is actually an opportunity for India, because we have been filling up this gap since last 10-15 years. We have come up with lots of chemicals, intermediates and materials. We have reached to a level that the imports are close to around $40-50 billion a year. And this opportunity is quite huge basically to develop these chemical entities in India, intermediates in India, and supplying them for the indigenous purpose basically. So this is one point, and the innovative strength, the way it comes out, filing of more than 1 lakh applications last 2 years successively, shows that the CSIR driven labs, they are doing a lot of collaboration work. Lots of inventive processes are being developed in the chemistry field, and especially labs like IIT Hyderabad, NCL Pune, and IIT Delhi, IIT Kanpur, they are doing a lot basically. And I can name like IIT Madras is having a hub of more than 250 R&D centers in itself, and they are making a huge change in terms of collaborations basically. So overall I would like to say that there is impetus, there is a huge gap which makes a lot of opportunities to come up with the Indian manufacturers to fill up the gap of $50-60 billion, because I think some of the expert policy makers, they have kept a target of around $1 trillion by 2040. So which is not a difficult target, because current situation is somewhere around 250 to 280 billion dollars we are doing presently. So we expect that by 2040, if we can achieve $1 trillion in the chemical specialty sector, so that's a big impetus, and there's a big gap which is available, and there are a lot of opportunities. I think industrial collaborations with the CSIR and government funded labs are doing a lot basically, and we hope that lots of new things will come out in terms of patent filing, and a lot of inventive steps are coming out. But I will touch upon some of the sensitive areas also in this, but right now I will leave it, and
Thank you. Well, I think it was mentioned earlier on that we have more than a lakh filings. So let me ask the audience, how many inventors are there in the room hall today? Or how many of you have actually filed patents past, present, or maybe in the future?
Sir, I am also.
मेरा भी हाथ खड़ा हो जाएगा. आपका. So we three are inventors out here.
Yes.
Anybody in the crowd? No facilitators, please. Actually, the guys who slog, I mean, you also slog, but I mean, those who slog in the labs and workshops. Anyway, let me move on to Maveen. I think I'll go. The question which I had actually for you in mind has been very eloquently spoken about by Patrick early on. So therefore, let me rephrase. Of course, what he stated was, and we all, some of us at least, those who are familiar with the working of electronics and communication industry, the technology industry, are familiar with the importance of standards. And he did mention about that. So I think the importance notwithstanding, maybe I would ask you at two levels. One, of course, is that do you see any specific regulations with regard to SEP in the country? And would you like to actually also tell us about, even though I personally know of, some case laws about where I suppose Ericsson was involved in one of them, about a dispute in that? Sure.
Thank you so much, Dr. Wali. I think I am the only academic on the panel, so probably I can take the liberty to kind of go a step further.
No, let me correct you. I work at the interface of business and research, and I am part of two academic institutions. Earlier, I was with IIT Delhi, and now with BETS Pilani.
Right, thank you. So, firstly, I'm glad that I was finally able to make it to the IP Conclave after two unsuccessful, let's say, invitations came, but I couldn't accept them because I had clashing schedules in the past. So very glad to be here today. Coming to the topic of standards, I think it was very nicely put forth by Patrick earlier. But India at this point in time is at a very crucial juncture. Not just in terms of its position on the Global Innovation Index, which Dr. Raghavendra mentioned is 38 now from 81 a decade back, which is a fairly decent progress, I would say. But also in terms of India being a contributor to interoperable standards or technology standards, because in today's date, we do expect a civilized society to progress and civilized nations to progress, or let me put it this way, nations to progress in a civilized manner, unlike what has recently been happening between the US and Venezuela. We don't want to take that route, or between Ukraine and Russia, or some of the other nations. The only way you can progress as a nation in today's date in a civilized manner is if you have the right kind of technology and the technological tools. And in that regard, China has shown the way over the last about 7 to 8 years as to how you could come out of your position, or let's say your designation as a so-called implementer-dominated economy to one which is slowly going towards the point of having a decent number of innovators or patent holders. Huawei is one of the leaders in terms of the number of patents vis-a-vis 5G in today's date, and they're very much well placed to be the leader or amongst the top two when it comes to 6G at some point in time of the next about 4 to 5 years. And it is on that note that the government of India took up this initiative and finally, of course, realized that India needs to have some sort of a presence on the global level when it comes to it being termed as a contributor, or let's say a major contributor to the standards. And that's how they were able to chalk out, I would say, an ambitious plan, to be very honest, but it's not bad to be ambitious. And that plan is to have a 10% contribution to the 6G standard, 10% contribution in terms of the patents, which of course we term as SEPs, in terms of standards to be there by 2030, 2031 when 6C actually becomes a reality. And we have about 5 years between now and then. But it is very important to actually realize the tools that are required or the tangential initiatives that are required to realize that dream of 10% contribution. I'll come to the cases shortly, but very quickly summing this up, government support is very, very important. Whether it is financial support or whether it is facilitating exposure for some of our startups, because where we are lacking is we have probably the best minds in the world. And they've shown that probably not just in India, but more importantly in countries like the US, Western countries, the UK, Germany, so on and so forth. Some of the top innovators in the big companies or the big tech, you will find a lot of Indian names there. So if they can be the leaders there in those countries, why cannot we have those leaders in our country? Ultimately, these people have gone from our country there in most cases. Very few would have been born in those countries. So somewhere there's something missing. And perhaps that support is available in other countries. I'm not talking about personal support, but institutional support, government support, and that's where it becomes extremely important for the Indian context that participation in global standard set activities which take place at SSOs or SDOs, whatever we used to address them as, stand setting organizations, stand development organizations, is made a reality for some of these startups. And they don't have the money to do that because it's very expensive to actually become a member of most of these SSOs. So some financial support is required in that regard. And yes, government is taking steps with respect to that as well, but a little bit more closer to what actually is the budget that is suitable. So that's of course one. I'll leave it here. And very quickly in a minute, summing up the cases that have happened in the Indian context of the last about a decade, 12 years. Yes, Ericsson has been in the thick of things, but also because Ericsson is one of the biggest innovators in the world. And Ericsson has a very good presence in India. And most of these cases that have taken place involving Ericsson on one side as the innovator or the SEP holder, and mostly Indian companies like Micromax, Lava, Intex, iBall. Gioni, of course, is, I believe, Chinese, but they had their Indian subsidiary, which is also part of a dispute. And the fact of the matter is, it's not like Ericsson only went after Indian companies. Ericsson has disputes with other companies as well, including China, more importantly. But the fact of the matter is, why is it that Indian companies couldn't read the market or sense the pulse vis-a-vis where there was a need for India to buckle up or Indian companies to buckle up and understand that the progression from 2G to 3G took some time, but from 3G to 4G and 4G to 5G took very little time. And what we are seeing now is from 5G to 6G, it's taking even lesser time. So you cannot lay back and relax thinking we are in India, nobody's coming from outside and taking over the Indian market. Unfortunately, our Chinese counterparts were able to read the Indian market better, and they were able to capture a sizable chunk of the implementer, let's say, not lobby, but the implementer community, right, in a certain way. But of course, I can build on that.
Yeah, so these are basically market dynamics that evolves and goes through various phases where the technology development happens either by your own efforts in the company, or sometimes you see the easy way around, and in turn you tend to infringe upon. So I think as the IPR regime matures, I suppose that responsibility will then rest with all the stakeholders, whether it's academia, whether it's industry, local industry, overseas industries, and obviously it's not everything is let's say wrong going on with one set of players, because then there is a wrong going on with other set of players who call themselves let's say innovators, more particularly in the pharma sector, where we have evergreening and stuff like that. But then we'll not touch upon all those things, and let's move forward. Now, I really don't know how much time we have, but I think let's have another quick round. I would request the members to be a little brief in their responses. Now, Vinaji, if I may turn to you and ask you whether it's specific, I mean, in your information or knowledge, if there are any specific instances of either sectors or companies in India who, by virtue of their IP portfolios, have developed proprietary positions or become globally competitive.
I did a quick search before coming to a patent database. So what I could see is there are a lot of filing which has taken place in the field like electronic communication, then the telecommunication, digital e-commerce side, then blockchain, AI, ML, and robotics, automation of industrial manufacturing plants and all that. So these things are happening in India. But to be really frank with the Indian, I couldn't see a very big global Indian company which are into the filing of patent applications hugely, But however, I could see a little movement, the baby steps being taken by different startups. They have come up with various different prototypes in the market also, and they have successfully brought in the prototypes. They have filed the patents, and these different startups were in the field of AI, ML, data analytics, then automation, of course, robotics, and many were there in the field of biotechnology, especially the biotechnology, bioindustry, which is enzymatic technologies, and the others were in the field of bioresearch, biomedical devices, so and bioinformatics, where we have there are a lot of startups which have filed the patents, and not only filed the patents, they have successfully brought in a commercial product into the market also, and they're doing pretty well in that direction. So that is, I will give my thumbs up to the biotech here.
Perfect. Thank you, Vinaji. Dr. Chaturvedi, I think I know for sure that your company has been engaging with many academic institutions. If there is any specific example with any particular university or academia, you need not name it, or a particular technology, I think, which resulted either from joint collaboration or from IP sharing or IP licensing, to your knowledge, which you would like to share without any getting into the specifics because of any privacy issues. So feel free to say that. And also, if you may also in the passing like to add on the maturity both of academic institutions and industry also with regard to licensing.
So I think you have put forward one disclaimer that but I would like to say that GFL, Gujarat Fluorochemicals, is since long back in collaborations with many of the academic collaborations as well as non-academic industrial partners from the globe basically, and many of the collaborations are with the US companies, European companies also. We are paying the royalties for licensing, and they are quite useful patents which we are having licensing and collaborations with them. But yes, in India, GFL has collaborated with large number of CSIR university. I can name some of them like IICT Hyderabad. We have collaborations. We have collaborations with IIT Delhi. We have collaborations with DTU. We have collaborations with IIT Kanpur. We have collaborations with IIT Kharagpur. Means these are the universities we have where we have sponsored the projects basically, and we have collaborations with Shiv Nadar University. We have collaborations with BITS Plani also. So since I have mentioned so many names, so nothing is particular basically. I am just talking some of the things very generically, and I will touch upon some of the very sensitive areas also, and these are purely my own comments, and they may be useful in making any policy or framework in the institutes as well, but they may be taken as my personal based on my personal observations and my personal comments. So As I mentioned that we have large number of collaborations with the CSIR universities plus external industries. And while working with these universities, we have done significant progress. We have filed large number of patents also. And recently we are working with DTU for a very recent program for Yamuna river cleaning work, wastewater treatment, and cleaning of the river water. Basically, we are indigenously developing the biomembranes basically, and bioreactors, basically membrane bioreactors, MBRs, with our own technology in tie-up with the DTU. And these membrane bioreactors shall be soon used in the cleaning of Yamuna river, and it's actually the indigenously developed technology, so it will have a lot of value in the time to come, because we are also coming up with some of the membranes for household RO purifiers, where a lot of hard water comes. You have to instead of using softeners, you can use these membranes and you can save a lot of cost, and they are very affordable solutions basically, which we are also coming up. These are all developed by us in tie-up, and we are going to come up and we are going to support the this Yamuna River initiative. So coming to the next important point, that while working with the IICT, IIT Kharagpur, and IIT Delhi, and many other institutes, I have personally, I am a technical person, I am a technocrat, I am PhD in organic chemistry. I did my law, and I did my several courses. I am a patent agent as well. So I realized while working with these institutes that IPR cells in these institutes, it's actually while discussing with the IPR cells of these institutes, there is a lot of upskilling is required for the IPR cells in the institutes, because what's happening is the scientists who are working, taking up the collaborative projects, either they are not able to understand the realities of inventiveness or the existing state of art, and the kind of development which is required, which is having the some inventive merits to come up. Plus, you should also non-pinch the existing scenario basically. So upskilling for the scientists is also required basically, and I am also of the belief that IPR cells in most of the institutes should be not the legal person, they should be technocrats basically, they should be techno-legal person, they should have a background of science, at least they can understand, they can realize the scientists that these are the hurdles, you have to resolve problem solution approach in these situations. That's one sensitive thing. And the other thing is, when you come up with the entire project development, you can't go back. So your money is already invested, and when you try to file a patent, you realize that you lack inventive step, and you lack so many other features basically, which could have been developed by the time the project time is over. And understanding of the scientists, scholars, professors, teachers in the institutes, it's very, very important. Rather, they should see an academic perspective by making the collaborative projects for the publications as manuscript in the international journals, or like that for the PhD submission, which is not a right way of adapting the collaboration basically. So when you started the collaboration, your first objective is to understand that collaborator wants something for the applied objective, for the applied use perspective, and when you come up, your first thing goes that let me complete my PhD thesis, let me submit some of the manuscript, let me get some international publication, while the priority should be you should file some of the inventive merits as a patent applications to be filed first, and your IPR cell should have guided them in a way that they should understand that what are the things which are novel and inventive. Rather, they should feel whatever they have done is actually able to be published in the manuscript, but it's not actually novel and inventive, it's not even serving the purpose of the collaborator as well. So I am just saying this is a very sensitive area, and I also believe that CSIR and the government initiative should also have some center of excellence to be developed in these institutes, where almost in all institutes, because collaboration does not mean you have taken a project for the development. Your technology transfer part is also very, very important area. And if you see the IIT Madras, the way they are doing, they have a technology transfer cell, a huge cell. 250, more than 250 organizations are working. They are doing technology transfer for their companies. And they have filed, I think, 417 patents last year, which is a huge number in 1 year. It's more than one patent applications every year. So it means that when you have an ecosystem of these many companies, and when you promote this kind of culture in the institutes, basically that you should have a technology transfer cell, you should have a center of excellence, you should have a business development cell. Then only you can cooperate much better with the industry, basically. So people say there is a academia industry partnership, and there is a term which is very often running is triple helix structure, that academia, industry and government should collaborate, and they should come out for this. But I think most sensitive area for coming out successfully in the field of collaborations is that science, the technology, the people in the domain of science and technology, they should be upskilled for both IP as well as technology, so that the things can come out and much better turnaround of the patents can happen. Filing a patents just for the number is of no value. So patents in silos, they are just a piece of paper, basically. And if you see the overall, in India, only 0.5%.
You have to, because we are short of time now. I think I have to give a chance to other members. Very quickly, Yogesh, if you would want to. No, thanks. I think you touched very important points about PTOs and other such things. Yogesh, do you think very quickly any PTOs? Okay. Any best practice either in the organizations overseas which you feel can be easily taken up, right? Given the fact that now we will be entering into new domains. Now we talked about it, was referred to whether it's the domain of AI, which is still needs to be regulated. Quantum is another area which we really don't know how it's going to practically shape up. Abhi to hum badi badi baatein kare, mission and all that stuff, but when it actually comes to the ground, we will have a different landscape of it. So in that context, you see any practices which we should adopt to further strengthen our innovation ecosystem?
What the Western world follows is the same that we also follow. Is that they have expert teams there, and the dedicated manpower that looks into tech transfer and IP ecosystem. One of the university, one of the session I attended somewhere, and they said that they are very particular when they file a IP first. They don't waste time on the things that are very immature, like the student coming with their inventions. They try to mature the things, and then at that level, at that stage, then itself they try to reduce the number of filings. For that matter, Cornell University, they have the filter at the first level, so that when that tech transfer offices takes care of the IP further, because filing IP is not the one, is the one the step or beginning step. Thereafter there is a examination stage and a maintenance fee, and that comes into your every now and then when you renew it, you have to give a thought, build a thought process every time, so that it is always a garbage moving in and moving out. So you have to be really very thoughtful when you consider at the beginning only which IP is important. So, and how much serious is the inventor and the team there, and also the foresightness about the possible partners that the university is in contact with, the local ecosystem where the university is set up or the institution is set up, just like a NML, National Metallurgical Laboratory of CSI, is very well placed in Jamshedpur, where the Tata Steel is there. So they are able to contribute in a research that will help the steel industry to come forward. So having that kind of knowledge is also very important, where the strategic partnership can be helpful.
Thanks. No, very important point with regard to IP management and ensuring better outputs later. So I think let me wind up with the panel session with the Manveen. Manveen, I think you are the youngest, so you should get more time perhaps. But anyway, I'll just take you to just maybe develop on 2 points. One is which I think we have discussed earlier on, that I know how many of the people here have startups, their own startups or initiating startups, have had, failed, risen up. And if failure is not, by the way, a bad thing, it's an asset class, by the way. I don't know how many of you know. You still have a startup? Excellent. So the question that is for Manveen is in terms of, Patrick, maybe you also would want to comment on that later. Is the threat of expropriation of IP, particularly with its young startups, early stage startups, and in the technology space, and then obviously in the big bad business world, the way world, half of the geopolitics is because of businesses. I think you know what I'm trying to trying to say. Patrick is laughing. So in that context, that is how you deal with it. And second related question is, when we talk of innovation and how to actually enable that, and what government can do, particularly if there is a sovereign kind of a fund. Maybe very quick remarks from your side.
Thank you, Dr. Wali, for that question. I think it's very important to firstly understand that there is definitely a need for some sort of guidelines as far as SEPs are concerned in the Indian context. However, there often seems to be a blurred line between guidelines, guide, and regulation. Japan has largely followed a mixture of guide and guidelines model. China has followed a model which is based purely on guidelines. Europe recently, or European Union recently, tried to follow the regulation route, or tried to take one, and it failed because they had to withdraw it. They released it in 2023, the draft guidelines on SEPs, and by 2025 it was withdrawn. And recently there was a case also initiated with respect to the fact that it was incorrectly withdrawn, shouldn't have been withdrawn, because some of the members were not in favor of it being withdrawn. But I think the biggest reason why regulation is not the correct way is because market is quite well equipped to handle some of these disputes. I'm not denying the fact that guidelines are required, and guidelines probably would really help the Indian case a lot, given that we have a decent number of startups and the startup culture is quickly booming. And also the government is very much in favor of encouraging more and more youngsters to actually take that route rather than just do the 9-to-5 job, right? And there are enough incentives offered by the government vis-a-vis startups, so to speak. But I also feel that there was a step taken in this regard in 2016 when DPIIT, which is now DPIIT, but at that point was DIPP. So DIPP had released a discussion paper on SEPs in 2016, March 2016, if I'm not mistaken, and comments were called for, or invited rather, from everybody, not just Indians, people around the world, and a lot of academics from the US, EU, UK, other parts of the world, and India, and even my university, we did submit comments on what is the correct way forward and what probably the government should do. But unfortunately, there wasn't much movement post 2016. We didn't really have any conclusive steps being taken. Fast forward to 2025, and we now see that again the government is interested, of course, in SEPs and 6T standard, because there is no way you can escape SEPs. You can talk about a lot of other things and how we could move forward and how we could climb up the ladder in terms of various different indexes, or let's say rankings and so on and so forth. But it is just not possible to neglect SEPs and how important it is to have a set of guidelines which govern how SEP licensing is supposed to take place in India. And I'm very careful with the choice of words, not regulation, guidelines, right? Because regulation means you are interfering, and then coming to lastly the aspect of expropriation. And I'll conclude with that, of course. The government did come up with this proposal, and it was a mooted proposal of sovereign patent fund about a year or so back, 2 years back. And the intention was, of course, to again eventually help the smaller companies or startups or Indian implementers by getting involved in SEP licensing one way or the other, and also getting involved in FRAND rate setting. Now, we don't have the time to get into the intricacies of what FRAND is. Fair, reasonable, and non-discriminatory, simply speaking, is what FRAND is. Is just a means of defining what the royalty rate should be without getting into the intricacies. So the government, wanted that probably should be something that should be looked into, but again, they had to eventually keep it on the back burner because that is actually not the right way to move forward here. Expropriation sometimes can be counterproductive in a country such as India, because on one hand you're trying to encourage people to innovate and take the innovation route. On the other hand, you are also telling them at the same time, or giving them this signal that, look, we are going to go into expropriation. Then that person is thinking, okay, I'm going to invest so much time, money, and of course there are patent holders or patentees here. It takes a lot for you to actually get a single patent. And then when you know at the back of your mind that, okay, at some point in time, I am staring at expropriation, so what should I be doing? So, which is why it all boils down to where are we and what do we need. And I'll just sum up by saying that we are fairly well placed in terms of what contribution we could make to the 60 standard, and a valuable one at that. But we need the government support. Our courts have done a remarkable job. No, we didn't get an opportunity to touch on the courts' job here.
Yeah.
But the courts have done a remarkable job, especially the Delhi High Court, in giving some of the most progressive orders and judgments vis-a-vis SEP cases.
I agree with
in the last 1 decade or so. So they've done their bit. But of course, judicial activism will be pushed back. So they can't do much. They can only do up until a certain point. The rest is up to the government.
Excellent. That's a very nice way to conclude and close at least our part. Now I think it's high time we open up the floor, and we'll be very happy to take some questions. अब हम नहीं बोलेंगे, आप लोग बोलेंगे, please. Yeah.
Best things CSR did to protect the traditional knowledge is to form a TKDL. So why not open the TKDL, database to public? Why it is still closed?
For that, it is a policy matter, but it is open to all the patent offices, and we have the agreements with the patent offices globally that is accessible to them, and that certainly research results will reflect those things, and what the openness of the PKDL is about is it is a strategic decision that we can make.
Yeah. Good evening. I come from oil and gas technology. Very high. So people are there. Although the panel made a very good effort at giving us the idea of academia, research, as technology. But one thing which was probably missing was how much is the extent of violation in India? Now, since if you see in the road traffic how much violation is, last 2-3 days police has been catching people coming from the opposite way, counter to the way, and there have been 1,500 I think single day. So I would like to know from your experience, anyone give, that how many complaints or how many issues or how many court cases we get of violation? How do we resolve? How much effort and money takes place so that we are working in ease of doing business, but people who are coming from out, they are scared of it. What will happen? Will it be followed or not followed? Will our design be copied? In our case itself, we have found that when we started, something like 95% of the equipment in a refinery, petroleum refinery, used to be imported. Today it's only 5%. 95 is legal. And we give our critical and non-critical parts separately to different vendors. But when we go to MSME industry, there is a large violation on it. even they do not know where they are violating. So we have to give them our drawings, our data, everything to work upon. But they'll separate here and there what's not. So I thought the awareness about the IP is so much lacking, and we are talking of so much what Manlin told, that Indian minds are good and what we have done is not better, but we are very poor in the compliance. What we are doing on that, we must work on. Thank you.
No, thanks. No, well, I think you took it very well. I think he did mention about enforcement and awareness. I think we're generally sure. I think it's a matter of time before I think the larger target group, whether it's MSME, the startups, or maybe the larger companies, will take cognizance of the importance, and the respect has to be shown in the IPR regime about the assets owned by the original inventors. I think it was when Dr. Patrick did mention briefly in his opening remarks. I think very well put. And I think for your information, I also come from oil and gas industry.
And may I answer? And I see in Indian law, it is that whosoever owns the IP, and I has to take care of that IP, he has to be vigilant about that. Your rights, it is your rights, so you have to be vigilant who are the thieves, and you have to take the regulatory measures.
Good. Sure.
Section 12A and 2018 Act of Amendment. Commercial dispute is a right category, all IP and other laws. So cases can be filed in commercial court under ease of doing business. Thankfully, again, I played a key role in setting up 22 commercial courts in Delhi, and now it is more than 60 here, and also in Bombay and Bangalore we did it. So all the cases go there, and there is a Department of Justice started a website called National Judicial Database. So you can go to there, you can drill down in which district commercial cases have been filed, and 25 high court benches, commercial benches, what kind of cases are being there, and subject wise you can search for that. Data, national, yes. Yeah. Entire data available in the National Judicial Database, commercial benches, 25 courts and district courts commercial.
Fine. Any other question? Yeah, please. I think quite a few of them. Yeah, yes, sir.
In the inaugural session, Dr. Ravindra, he mentioned about one district, one
ODOP.
ODOP. Now it is a 4-year-old. The Prime Minister knows from the Red Court, one district, one product. Now you are all experts in the IPR and taking that. I want to ask, during these 4 years, how many districts have developed the product or export and for the international also, or it is only a slogan? This is one question. Otherwly, you see, the patent filed, you said 1 lakh patents are being filed every year. Should we be proud by the number? I want to ask how many have been commercialized. Go to IIT, go to GTU, I am from GTU. When I ask how many patents you have filed, they say 100. How many have been commercialized, how many you have sold, say 0. So I think important, we should feel proud that so many have been sold, so many have been commercialized. That is more important rather than the number.
I'll just try to answer this. The second part, the first part maybe Raghav would like to ask. I was part of the IIT Delhi system, and I think what you made an observation is actually generally fine, but not completely true. For example, I can say with authority that when I was at IIT Delhi, not that the situation has changed, it's still the same, maybe better. We were monetizing at least 5 to 10% of our IP. We were conservative in filing in the first place. हम लोग में ज़्यादा 500-600 नहीं होते थे, हम 100-150 के आसपास रहते थे, और we used to ensure over a portfolio that at least 5-10% of IP gets commercialized or gets transferred. I think one of them was transferred to JLPL, I think. But after that, on a larger scale is true, we should worry about monetization. Having said that, whenever we create tickets or a large number of different portfolios, theoretically all of them have not to be commercialized, because the purpose of filing differs from case to case. Many times we have to create a ticket for a defensive position. Sometimes we create a ticket portfolio for defensive purposes, and many times it's fully in terms of monetization. But anyway, that's a long debate. We can discuss it offline. But the second part is ODOP. Maybe आप इसमें शायद कुछ बोलना चाहेंगे. It's still evolving. In progress. Work is in progress. Thank you. Any other question? Yeah. Okay. Yeah. Last. Ajit, yeah. You got up. Yeah. Ma'am, again, he actually raised his hand before you. After this, maybe you can come.
Good evening, everyone. My name is Vishesh Bansal. I am from Amity University, Noida. I am in my pre-final year. So my question is, how do we balance openness with protection? In collaborative innovation, where should organizations draw the line between sharing IP to accelerate innovation and protecting IP to preserve competitive advantage?
Who will answer me? I don't want to answer because I want to keep quiet.
Openness and the owning your own IP and sharing the IP, both comes hand in hand. And it depends on where is your strategic interest and where is your non-strategic interest. So maybe the non-strategy may become the further strategies also, and you have to be in a area, you have to make the you are working in industry, which area you can say, it is a industry in which you are working, and the wideness of that area you need to cover. So you cannot do independently. You need to work in some tangents also, so that you don't want to share all your expertise or the resources into that area, but you need that area also. So to have in that to work in that area also, you need some kind of partners, some startups. So working with those startups, you can gain that to get the synergy from that area also, and then further you can scale it up. And if there are any kind of fruits, then you can take it to the next level. You can see the working of ITC in that matter. What they do is they work in they do mergers and acquisitions, and that way they are the leaders in the FMCG. So collaboration comes with the strategy also. And openness, one area where openness can be seen is that open innovation is seen is like a OSDD program, where they it was for the drug discovery in open innovation system, wherein the tuberculosis, like this is where the global industries are not interested in, but it is a matter of concern for India. So we try to make a platform for OSDD online, and where all researchers contributed there and tried to discover the molecule.
So more information, I think Dr. Manmin is there, so we can discuss with them. I think, ma'am, we will be doing injustice, ma'am. I think you would want to ask a question. I think that will be the last question. Maybe we can then otherwise interact later on. If you have a question, please. Yeah.
I'm Dr. Pallavi Gupta from JIMS Greater Noida. I'm law faculty. So being law faculty, I want to educate how law faculty can go for IP generation, especially for getting patent?
It's not a very straightforward question, if I'm very frank here. But I think it's purely down to one's personal interest, because we as IP academics are expected to do a lot, not just teach, also research, and sometimes we are into consultancies and similar stuff. Yes, there's no denying the fact that we are pretty well placed in terms of also being able to let's say file a patent application, because the technical know-how that is required, or let's say that you attain over a continuous period of time while teaching, let's say 10, 12 years, if you're genuinely interested in doing that, it's possible. But what I would recommend is that in a lot of cases by yourself it may not be possible. It's best to actually again collaborate with others who probably have already done so, or friends from the industry. Because I think one thing, and just end with that, one thing that has been missing, and I didn't get a chance to say it earlier, is the collaboration between industry and academia, right? And this is actually a very fruitful contribution between industry and academia, where there are certain academic aspects on which the industry banks on us as academics, and there are even more intricate aspects or the practical side of things, or the market realities vis-a-vis which our industry friends are better placed to advise us. So probably the best thing would be to actually have a dialogue and collaborate with our industry friends. Some of them are sitting
So
here.
only in law faculty cannot do that. We need to go
You
for
can.
collaboration, right?
Yeah, of course.
Thank you.
I have a point. I don't know how many of us we know of patent trolls and the likes of intellectual ventures and all that. So I should not be mentioning it here, but it's a good time, to start with and look for individual grassroots innovators, if you think of, and you can create a capital out of it. And you can start with that. That would be a good initiative, and that would give impetus, I would say, to these inventors who don't have much capitals to file patents, to commercialize them, even to look into the commercial aspects of what they have actually built.
Actually, ma'am, I heard so many
Ma'am, I
research.
think we'll close. I think we can have it offline, and I think,
but
I think I will not take much time. I think you please take over. I think I'd like to thank my panelists here and you all first for being so patient and bearing with us. Thank you very much.
We now begin with our second panel discussion, which is IP for protecting creativity in the digital age. As creativity increasingly moves to digital platforms, questions around copyright, royalties, and fair use become even more critical. Our second panel discussion addresses these issues head on. May I now request Ms. Hiteshi Trivedi to present a token of gesture to our moderate, Dr. G.R. Raghvendra, Senior Consultant, IPR, DPIIT, Government of India.
May I request Ms. Hiteshi Trivedi to present a token of gesture to our moderator, Dr. G.R. Raghvendra, Senior Consultant, IPR, DPIIT, Government of India. I now request Ms. Purvi Pandey to present a token of gesture to Dr. Alka Chawla, Professor in Charge, Campus Law Center, University of Delhi. I request Ms. Hiteshi Trivedi to present Dr. Sandeep Marwa, Chairman, AAFT Education Group and Chancellor, AAFT University of Media and Arts. I request Ms. Purvi Pandey to present a token of gratitude to Mr. Akshay Raju Saxena, Music Director and Director Composer, T-Series and Member Music Composers Association of India.
Hi, how are you? How are you doing?
I request Ms. Hiteshi Trivedi to present a token of gratitude to Ms. Rumpa Banerjee, Head Marcom and Member Relations, Indian Performing Rights Society. We look forward to hearing diverse perspectives from academia, industry, musicians, creators to help us delve into this subject. Over to you, Dr. Raghvendra.
Vande Mataram. Good evening to everyone. Again, I would like to congratulate IPSPC for organizing this IP Conclave and IP Award Function 8th edition. I would like to welcome Dr. Sandeep Marwa, Dr. Alka Chawla, and Rumpa Banerjee and Mr. Akshay Raj Saxena. We have a music composer and we have a person who manages the rights of the music composers and authors, and we have a professor who gets into deep into the concept of IP policy. Again, we have a great creator, film producer, owns a film making company from Noida, Dr. Sandeep Marwa. Is a well-known person in the film, Bollywood film industry. India, this is the industry which has made India number one in the film making, and the digital age, especially the WIPO Internet treaties started extending protection, what the basic minimum standards from Berne Convention to the TRIPS agreement gave for the copyright protection through the internet. the WIPO Copyright Treaty in 1996 and WIPO Performance and Phonograms Treaty in 1996. In the 2012 Copyright Amendment Act, we have incorporated all the minimum standard of WCT and WPPT, and our act is now taking care of completely the protection of copyright in the digital age. But the new exponential technologies like artificial intelligence, machine learning, deep learning, and neural networks, especially the Gen AI, has created havoc with the rights of creators and also the owners. And considering this and considering various court judgments in the US, UK, and EU, especially recent judgments from Germany, Government of India set up a committee, that is Gen AI and Copyright. The first report has come out recently, and you can still give comments if you're not given comments. Data has been extended up to the 2nd February, 6th February. So still you can give comments on that, go through that white paper, how it is going to affect your rights, whether it is a film industry or music creators or authors. Now, let me ask a question from the creator's point of view, from the gentleman sitting right to me. In a film industry, earlier digital age, VFX was the main creator. Now the AI is being used. Now authors are writing script and fine-tuning with the AI, dialogue writers, even the music composers. Now AI has been used in the recently Narsimha Avatar, the film, which has been very successful, and of course the Hollywood Avatar, which is running in the States. So what is your experience of protection of film in the digital age? Whether Cinematograph Film Act and Copyright Act are sufficient, do you need any amendments?
Well, good evening, everyone. What a pleasure to be here this evening with all of you on this beautiful, well-designed IP conclave. Let me take this wonderful opportunity to extend my heartiest congratulations to the organizers and my special thanks to them for inviting me here and giving me this opportunity to be part of this program. Let me start with these two lines कि इतना रहे ख्याल सताने के साथ साथ कि हम भी बदल रहे हैं ज़माने के साथ साथ. If you go back, you'll be surprised. Most of the creative people, they were absolutely unaware of what law is all about copyright. They're not even bothered about it. Most of the creative people, I'm talking about not only in India, even abroad. But slowly and gradually, the awareness through television, through radio, through newspapers, through lawyers, I must say that, and through different cases which has been actually getting a final verdict from the courts, people have come to know that, oh my God, there is something like called copyright and I have already committed a mistake. And this has been done by many people in this industry. Yes, it all starts with when you write, you don't know. You think you are a creator of a story, you are a creator of a script or a screenplay, and you are actually carrying it with you and been narrating the same to many people at the same time. And suddenly you realize that a film is already being made, you're still struggling and narrating your story to different filmmakers. Yes, that's the time when we created a Body Writers Association of India and Indian film industry, where you can write a story, write a script, get it copyright, get it stamped, and legally copyright, sent to go to your lawyer and get it copyright, so that nobody should actually copy your story. It starts with writing lyrics, writing scripts, screenplays, stories, whatever. Then it comes to music. Music, people never realize they've been actually picking up the tunes from foreign films. They've been picking tunes from different setups. Yes, only thing which was earlier allowed was to copy regional numbers, regional songs, or old numbers which are 100-year-old music. There was no copyright for that. But yes, today things have changed. I'm just giving you a little brief about what exactly it was, and then I'm coming to the answer. And this is how people realize that it is very important to have a copyright done for your music. which is essential, otherwise somebody else will copy it and create many different numbers out of your number. Yes, today is a digital age. Things are absolutely free to the world. Even I have committed mistake because I was unaware in 1993 when I got into education and we were started making short films with our own students and giving a lot of liberty to our students to create a film from my production company. But that time there was no music right for that. And we used probably some cinema music, some tunes from English films as a background music for those short films, which we learned after many years when those films we could not upload on YouTube. I hope you got my point. And the minute we started putting those old films on YouTube, they were outright rejected instantly by saying immediately throw them out or change your music. And of course, it has costed me hell to change the music, to change the background music and things like that. Coming back to now, we are much ahead even of that. When it comes to AI, initial first 2 years, there was no law, there was no system, there was no copyright system for AI. Everything is open to the world and people have used or misused whatever you want to say. They have done it. Things suddenly people realized with the latest cases which have just been given a verdict and Salman Khan, Akshay Kumar, people like this, they have gone to the court not to even use their pictures without their permission. It was a custom in India to use actors' picture outside the shop so that they can sell their product much more by attracting people and showing them that this particular star is a part and parcel of my shop, which is all bogus actually. But then people do get attracted to those kind of star pictures and used to buy from those shops which are carrying stars picture outside their shops. But now all that is finished. No more creation of a picture out of picture. No more film you can create even out of AI because this is now there is a restriction on it and one by one. But the only problem right now is that you have to go in person and get your rights secured through court of law. If you can do that, then after that nobody dare to get into a malpractice. It will become a malpractice and then you are saved with your copyright to that extent. So this is a small tiny explanation and a story which I'm trying to narrate today. And now I'm happy that the Indian film industry, which you know is the biggest film industry on this earth, and not only music, we lose something like 5,000 crore rupees on piracy. We lose something like 10,000 crore rupees every year on cinema. We make films, but they are copied by some good intelligent people and they are shown to the rest of the world without permission, without giving the rights or the token back to the producer.
Thank you. I'll get back to you on the piracy later. Now the film industry perspective all, but one of the persons who contribute to the film by creating music, Mr. Akshay Raju Saxena is here. There are a lot of problems in exercising your rights once you compose your music. So, what are the normal problems you have faced apart from the normal piracy issues? And can you explain to the public how Copyright Act is helping you to protect your creative works, especially the musical?
First of all, I would like to thank everyone for inviting me. So, there are two things in the industry. Even if you are not a musician, you can just go through an app, pay the subscription, and you can become a many of the persons, many of the musicians, many of the non-musical people, they are making music just by using some paying the subscription. So copyright thing is not a very you cannot say it will save your music. Sometimes they are making covered songs, unplugged songs. But if you are viral,
if your videos goes viral, if your track is being taken by T-Series or some big companies, then they make all the legal formalities and then you can save your music. But as a composer, one person should have the patience and he or she should do all the legal formalities that sir mentioned, and then he can grow up in the industry. The problems that comes for the composer that he is not having such funds to release their songs, so they go to the famous music directors or the famous musicians, then they take their songs, they take their music, they mention then ki we will write your name as a ghost producer, but you will not get the credit in the industry. That happens. It happens with me. 10 years it happened with me, and after working hard for 15 to 16 years, then my name got into films. I've done around 105 films. I went to Cannes Film Festival also, Short Film Corner. I've done many films. So that happens in the beginning. But if you have some patience and if you want to grow in the industry, you have to learn from your seniors, and then only you can survive in the industry.
And Akshay Raju ji mentioned about the rights management issues. Rumpa, you have been in the IPRS. IPRS is in Indian Performing Rights Society. It manages performing rights. That is underlying works. The rights of the authors like Guljar, Javed Akhtar who write songs, the lyricists' rights, and people like Akshay Raju who compose music, who are the creators of musical works. Both rights are managed by the IPRS. So, what were the problems before the amendments, and one other amendments are protected your rights and recognize that that IPRS can manage the rights legally as per the Act, and still there may be some problems in addressing this kind of thing. So how you are managing this?
Yeah, firstly, kudos and congratulations to IPTSE for this seminar and this award. And the best part of this this event is that, as Dr. Raghavendra already mentioned, that the students and the youngsters are in the room. So it's very important in India for the younger generation to understand the value of IP, and these kind of conversations needs to happen more. And we are grateful to have IPRS in this room. Thank you for inviting us, because for long we have been wanting to talk to people who are being affected and to people also who are using music. Because as Dr. Raghavendra said, that what was the difference like pre 2012 and post 2012. So we have to go back a bit into the history of Indian music. In India, music was never created for music. Music had been mainly dominated by films, and music was made for the films. So like a project, like you had a screenwriter or a dialogue writer or a director. So when a movie is being made, so the director and the producer, like say an RK studio, like Raj Kapoor Sahab called for, say like Lakshmikant Pyarelal and Anand Bakshi ji. So he narrated that this is my movie, this is the story, these are the actors, these are the situations. So I need 8 songs for my movie. So then the composer and the author, they used to go back, they used to come back with the lyrics and the composition, and they used to be paid upfront for the composition and the lyrics. But they are not the business people. They don't have the know-how to now make the music, because lyrics and composition are the raw materials. Now you need to have a singer, you need to have instrumentalist musicians, like a recording studio to now make this lyrics and composition into a song. So then a music label was brought in. The music rights was bought by a label. So maybe a Saregama bought the music rights of Bobby. The author-composer was paid, and that was the end of it. So now Saregama bought the rights, and the music got released in the movie. It was okay till the late 80s, early 90s, because these creators, they got their money for making the music, and the music got paid in the movie. But in the 90s, we saw the private radio stations, private TV channels, telecom, and everything coming in, and they were all using this film music to run their channels and businesses. The labels made money because they sold those music to these business houses. but two people who never got paid for their music being now commercially exploited everywhere were the lyricists and the composers. So then a group of creators led by Javed Akhtar Sahab, he was then the Rajya Sabha member, they started conversing with the government. Like Congress was in power, BJP was in opposition, but this was a landmark thing where both the ruling party and the opposition came together and the amendment happened. So what was the effect of this amendment? Pre-2012, author's right to royalty was not established. So if a song is being commercially exploited, an author didn't have the right to claim for their royalty. Even if IPRS was established way back in 1969, we could not exercise our power of being a copyright society representing author-composers because the rights were not established. But post-2012, and that was the best judgment ever happened, and we have one of the strongest copyright law in the world. The right to royalty of an author-composer as per the copyright law is inalienable, which means if an author-composer even writes off the royalty rights. Today, if Mr. Akshay is given a hefty amount and told to write off his royalty rights to the producer or even to his family, it is null and void in the court of law. IPRS will collect the royalty and pay it back to the author only. And it will go directly to his bank account, not to any other third party. Even if he is having a manager, even if he is having a publisher, the money will not go to anybody's account. It will only go to the author-composer's account. And this was done purposefully because Javed Akhtar Sahab and the government was aware that how vulnerable creators in our country are. Like we just heard a story that ghostwriters and all. So we know that an artist's earning is limited. So there are temptations of writing off your rights. But in India, you cannot. And that's a very big thing because in West, you have the option of buyouts. You may be paid upfront and you can sign off your rights. But in India, buyout is not possible because your right to royalty is inalienable.
But this is only possible if he's earning the money. That's the exception. You have to keep that in mind. If producer has gone into losses, he cannot share that money. There is no money to share. But if the film has done well, if songs are doing very well, and if there is an extra remuneration, out of that, a percentage goes back to the writer and to the
Actually,
music director.
I am the person who drafted the 2012 Copyright Amendment Act. There we introduced the right to receive royalties. When you are a producer, make a film and release it in the PVR multiplex, and for that one-time payment has been by the music writer and author, songwriter or a story script writer, that is done. When film is super hit, like Durandar.
Correct.
Durandar super hit. I think I've seen after coming out of the film, I was just waiting for why March? Why March? Why can't I come back and watch the second number 2 continuation serial? Like we see in the web series. So, but any exploitation of this as a ringtone, callback ringtone, OTT, YouTube, that is what in 1977 Supreme Court, Eastern Motion Picture Association versus IPRS, Jaswant Singh said, when he said that Section 17, B and C, all rights are gone to the producer. But okay, as a film, as a total copyright, as a film producer, you have. Because if copyright is split, you can't sell that and you can't make money. But when his song is taken out of that, that's what the Justice Krishna Iyer wrote in Obiter Dicta, and the penumbral area of policy making, further exploitation, out of the cinema hall exploitation. Their rights have not been neglected. So, entire world, if you see the CSAC, Confederation of Societies of Authors, Composers, 126 countries of 240 societies are there. They all share 50-50 royalties when song is played, ringtone and all that.
It all actually started with ringtone.
Yeah, I know that is
Because,
digital. It started with the radio and public performance in the restaurants. The first copyright society was formed in the France, same when songs were played in the restaurant. So what should be the rate? At least a peg of beer or a cup of coffee, that should be the royalty to be paid to them. And then later the digital age came. Digital age, every click, every download to see, when listen only or watch only. So this was not coming, that money was not coming 50%. Music companies were getting 100% for the sound recording rights. Again 100% for the performing rights. So performing rights, they have to share 50% with them. That's what we ensured in the amendments. And then coming to the digital age, the conceptual thing I would like to ask Professor Alka. Recently in London, 1,000 music performance singers came out, protest against the kind of the AA company exceptions. There were TDM exceptions, text data mania exceptions. They were extending like EU. They released a silent album. They called it "Is This You Want?" That title of the album. 1,000 singers' works were included. Later, our grand old man Paul McCartney also joined, his song also included. But actually, there is no song. If you open that album, it's a silent album. So it's a slap on AA companies. Look, man, you are parasites. You are existing on the pre-existing work, the music created by him and book written by Alka and film made by Dr. Sandeep and song written by them. If these are not in the public domain or some website and database, you can't crawl and scrap and make a new work. So you're all parasites. So you take consent and pay license, take license and pay money. So, and India, thankfully, I fought for the creators' rights. Finally, the white paper has come out to take license. No, nothing is free. Kuch free mein kuch nahi milega.
Now you have to even take license for any public event.
Yeah, public event
before
also.
playing
Public
any music.
performance. Yeah. So what I want to ask, copyright is automatic. The moment, every film, every song, every lyric, every dialogue need not be registered. Of course, while registering, Section 48 says that, 44 says that it gives prima facie evidence. The certificate gives evidence. Now in the digital thing, but there should be originality. So, do you think that AI creations, there is originality? Can AI can be granted author because people say that AI autonomously creating it, but copying it? Or it can be owner. Can you please explain this concept to them?
Thank you so much. Thank you, IPTSE, for calling me. I am a teacher, so I'm going to talk about very fundamentals after listening to all these challenges, so that things become slightly clear to us and we can also go ahead thinking what is to be done. First of all, what is the concept of AI? That is artificial intelligence. We divide it into two parts. One is what we refer to as AI assisted technologies are used in order to create something. That means there is a human element there. You are using a tool and then creating something. That is no doubt about it that it is copyrightable. It is protected by copyright. But second is when there is no human element, like all of you are using ChatGPT. There is a human element of prompting questions to the software, to the, whatever that ChatGPT is. And then what happens, it uses algorithms and gives answers. Now, how has this happened? There's an OpenAI which has been produced by OpenAI in San Francisco. Now, what they do is they've taken so many databases, whether online or offline databases are put together, and then the software is trained to give answers. Now, when you ask something and 5 people ask the same thing, there may be a similar kind of a product which may have appeared. Now, the question is there any infringement of copyright? Now, we all know recently in August, what has happened is that a case has been filed in Delhi High Court against ChatGPT, saying that they are infringing copyright. Right? Now, given this kind of a background, the question is, what is the meaning of originality? And we all know originality is a concept which has been creating problems since the day the word was there.
Because what is original is we are not talking about novelty. We are not saying something coming up for the first time. Ideas are not protected. Expressions of ideas are protected. And expressions of ideas are what is we refer to as original. So the question is whether the AI is producing something original or not. Just to give you an example on which most of the problems today are being based and argued are, first time when camera was used to produce a picture. Now when you use a camera to produce a picture, it is mechanically produced. So the question is, should we give protection to the pictures clicked by the photographers? The answers given by one of the courts, this came in, I think, in 1884, if I'm not wrong, and the answer given was that yes, it should be protected because the cameraman, like we have a cameraman here, he knows which angle to place, when to take, what is the framing, how much frame is to be taken, how much light is to be used. So there is a human element which is present, so we protect the photographs. But today what is happening, I just give some command saying, using this painter's concept, or I say that these are the three writers, and three writers' original concepts you use and you make a poem. Now I'm not doing anything, I'm asking the machine to do it, and machine creates a poem for me. The machine is making a picture for me. The machine is making music for me. So can we protect that or not? That is what is the question today. And till now, whatever I have read, I may be wrong. All the jurisdictions, most of the jurisdictions which have legislated on this have said that if it is humanly produced, you are doing it, you are producing your music, it is protected. If you are using an AI tool and there is a human element, it is protected under copyright law. But if there is no human element would be there in asking questions. But the production, the output is done by the machine. That is where the entire problem which is lying. And I feel that, as you said, originality, the first question that needs to be answered is, what are our legislations talking about? And if I talk about the Indian Copyright Act, and if you look at the copyright manual, which is placed by the IP office, they say that a natural person can only be an author. And if a natural person can be an author, then only an author can produce something original. So anything produced by AI, by algorithms, not using human element, cannot be protected under our act. So what is it that we are supposed to do? So at the moment, what we are supposed to do is we have to think about ways and means, whether we should have it in Copyright Act. I may be wrong, but I personally, feel that Copyright Act is meant for natural persons, for increasing their creativity. So whatever tools we use for humans, that should be included. But for AI produced materials, I think we'll have to look somewhere else, either for a sui generis law, or I can't say anything at the moment what should be done, but there has to be a separate aspect which has to be seen.
Yeah, you are right, Professor, that entire IP system, not only copyright, entire as system based on the personality theory and incentive theory. Because of incentive theory, patent gets 20 years term, copyright life of the author, minimum standard 50, but India was 60. And selection arrangement, even though AI assisted works, originality should be there. If there is no originality AI assisted, even the human involvement is there, no copyright can be given. Many as US Copyright Office rejected many applications, but recently they registered two because there is a originality in that. Selection arrangement is original. But coming to the films again, Dr. Marwa Saab, again I going to my favorite film, Durandar. Durandar, first week I rushed because I knew about Mohan Sharma ji, on whose life, Major Mohan Sharma, and whose life this Durandar is the original Durandar. Got into Taliban, ISIS, and then came back, and then when they were invading India, and then he fought with them and died, got the Ashok Chakra posthumous, and big seller to him. But when film release, it became so famous all over the world, even in Pakistan. 4 million downloads. illegal downloads. What happens to your investment if such is happening? And an entire world, only one high court very aggressively protects yours, Delhi High Court. There is a system they developed, injunctions, called dynamic injunctions, dynamic plus injunction. Even unknown people, these injunctions are applied. Even after when the suit is filed, 100 websites are there.
So
when they're taken off, even new sites come, again need not go and file this, register will give you permission. That's a dynamic, it's go on, go on, go on. But the kind of piracy is still there over websites. So what steps you are taking in India? And what I get news is that wherever Indian people are there, the US, EU, especially the London, these areas, Indian film piracy is more. So how we are protecting this?
Sir, I tell you very frankly, by the time you submit your application in the court of law, you've already lost the game by that time. It's a process. And I think it takes about 3, 4, 5 days by the time you are asked to come and present your case. It's 7, 8 days and you've lost the game. Millions of viewers have seen the film. Thousands and thousands of copies have already been made all over the world. And people are feeling very happy that they have seen one of the best film, Indian best film, without paying for it. Now, we are the losers. The whole industry is a very big loser. They estimate, I just mentioned, that more than 10,000 crore rupees Indian film industry is losing every year only because of piracy. It's so unfortunate, it's so sad. And it all started when there used to be a print. I mean, if you can recollect that, the whole film used to be delivered into the theater for 35 mm size, and those films used to be put in on the projectors, and people used to copy from their cameras and from their video cameras. So we tried to save all those process by putting a lot of vigilance, by creating societies, by complaining to the police, by making other departments more vigilant about these kind of things, and it reduced actually. Then this next step, what we took into account is the satellite way of projecting films into theaters. So now there are about 8,500. That time there were around 12,000 theaters, and out of which roughly 8,000 theaters were ready for satellite projection. So the film used to be delivered and at one go, and from, let's say, from Bombay office or from a Delhi office, and all these theaters used to project cinema. Like, for example, if I've hired 100 theaters in India, so all those 100 theaters will be projecting films at the same time. So 6 o'clock, 6 to 9, 9 to 12, so sharp at that time, film will start. And that actually saved a lot of piracy to start with, but cameras are always there. And you could not.
But in 2023, Cinematograph Act amended and anti-camcording provision has been introduced. Very hefty fine.
With hefty fines, but that's
after
if you cross a red light, there is a challan. Everyone knows about it. Still, people do it. It's so sad.
And then coming to the digital film distribution, 2012 amendment, why we introduced criminal remedies against anti-circumvention measures, we said. The technological protection measures you use encryption on the digital film. You put watermarking, digital number.
Sir, all those things were...
the data, when film digital copy is pirated, from which theater it has been pirated, which distributor has been. Still, you're not able to control this?
No, see, this I was about to come to that. When the films were transferred into CDs, we created a setup that CD used to have a life. One show finished. After that, you cannot play the CD. So it's a one-time projection. When a format came, a DVD, then DVD had a system that you suppose if you have hired a theater and it's a 7 days and 28 shows. After 28 shows, the DVD will automatically crash. You know, and these kind of, and then there is another provision in those DVDs that if you're trying to copy DVD, the DVD will crash. So it became the responsibility of the theater owner also to protect the DVD at least for 28 shows in a very secured manner, so that even his staff should not misuse that provision of copying. Because if he's going to copy, the DVD will crash and he will lose his rest of the shows in theater. So all that we have practiced, but the technology is moving so fast that it's difficult to cope up with the technology. People have better minds than the inventors, trust me. So you invent and there is a one guy who's ready to copy and maybe do better than that. So right now, I'm happy that it is through a satellite system where a lot of security is being given, but it is unfortunate that films are still copied from one or other angle, and they are out even before sometimes the final releases. So this is a massive thing. The whole thing can only be stopped unless and until people think about us voluntarily. That we don't have to ruin the industry.
Another argument, people are promoting piracy. Even educated people, white collar, even big money guys also, when freely given, they will watch. But the poor and middle class, not middle class, the lower middle class, that we can't afford a 400 rupees ticket in PVR, and that is the reason why. And we go to PVR, and there is a water bottle, 20 rupees water bottle inside 100. 60 rupees coffee is 300 rupees. So these are the things, family going there enjoying is a problem. So when they get Durandar illegal download, they all sit and watch on the TV at home. So is there any way to regulate the bringing down the price of the tickets and the other things sold in the theater? Any your thought of that?
The second alternative, what is available right now, is that once film has done well in theaters, the film automatically comes on OTT channels. And when you have OTT channels, and if you really want to see some new film, you have to pay sometime separately for it. Or you're paying your OTT charges, which covers the cost of the film also, because the OTT channel has already paid a good amount of money to the producer for actually relaying that film on his channel. So that's another provision which has come up and which is quite satisfactory and paying. Let me tell you, on this 1st January, I have become the Vice President of Film Federation of India, which is the mother body, apex body of the country. And trust me, when I'm listening to all these things, I'm noting down, and I will take all these points into consideration in our board meetings.
So
how best we can.
Congratulations to you. And I used to interact with FFI during the 2012 amendment with S. Chopraji and a team of members. Supran Sen used to be there at the time. And thank you very much for your inputs on that. Coming to the music.
So one thing I wanted to say.
I'm just coming to you.
Yeah.
So how are you managing the sampling issues in the digital environment? And sampling is a big problem. And also when your works are uploaded on OTTs, especially apps like the Spotify or YouTube. So what is the present royalty mechanism of these digital platforms are favorable to you or not? And the AI apps you mentioned about the Suno. Suno creating the music has become very threatening to the survival of music
even giving the
composers.
stems of the music.
And then film producers, instead of engaging you, not even ghostwriting, they say AI will create better music. So what will happen to your future in the digital age?
So we have Mr. Ashish Saxena with us. He's a VFX director. He's done many films. 5 days back, his reel got viral. He scored around 200 million views. It got aired on Doordarshan, Uttar Pradesh, everywhere. It was on Ayodhya.
Ayodhya.
Ram Mandir. and he has all the copyrights with him, but it was copied by Uttar Pradesh government. So we sent a mail to them.
Really?
Yeah. So we have all the copyrights. So in return, we got a reply. They sent a mail to us. God bless you. So we cannot do anything. So we sent a, sir, we have created this clip.
You have to engage a lawyer and
No,
Allahabad
he don't
High Court
want to
will
do
give
that.
you answer.
Yeah. So it happened. It happens. And we're talking about the copyrights. There are some sites, duke.com. You send your music to them. They release it on all different audio platforms. And once it got released, the company owners, now what they do, initially they used to take the track and they used to release it. But now they ask for stems, bass, rhythm, chords, guitar. If you have all the stems, then that means you are the owner of the track. But now such apps, they are also giving the stems also. So you can extract the audio and make such stems. So it happens.
One twist to your work used by UP government there is a copyright exception for government use. That is section 52(1)(ZA). There, songs can be used for the bona fide marriage. Barat mein use kar raha hai, but other bona fide ceremonies, it's not infringement of copyright. That's why IPRs won't enter the marriage hall, unlike PPL, license le lo. Government using songs. Abhi 26 January aa rahe hai. I sit in the Vanija Bhavan, Commerce Ministry, DPIIT. I can see the boat club. उधर से म्यूजिक आते रहता है. अभी तैयारी शुरू हो गया. ये देश का धरती गाना आते रहता है. Then so government using songs need not take a license like a hotel takes a license or FM radio takes a license. Here, tell me whether government use Ayodhya for government promotion work.
Sir, it's Doordarshan Urdu.
Yeah.
Radio.
Yeah. Wait. No. Again, if they are not used for the government program, used for I'm explaining. News and current affairs. Again, there is a exception is there. Not only Doordarshan, even NDTV, Aaj Tak, or Hamara Bhai Sahab from Republic, he can also show a clip there, but not commercially. Cannot put advertisements and make money on that. The moment they are putting advertisements and making money, then aap kada ho jao, royalty le lo uska. If they are not commercializing it, just for on a particular occasion they are showing it, news and current affairs, for criticism, review, or informing, they are put that, then it is copyright exception legally diya. Tab aap Allahabad High Court nahi ja paoge. This is it.
So there is one more concept which is also like misused and all fair use.
Yeah. Well, that's what.
So you can talk about.
India there is no fair use. Copyright section 52 fair dealing exceptions.
But there was a provision, if I'm not wrong, there was a provision up to so many seconds you can use the clip. No, earlier I'm talking about. Now it has been finished after all that what has happened.
Please, it is only a myth. लोगों में एक myth फैला हुआ है कि मैंने 30 सेकंड यूज कर सकता हूँ. Neither Berne Convention 1886 से लेके TRIPS agreement recently 1996 की WCT, WPT, no, neither US law, EU directives or Japan, China, कोई भी देश में कानून में या Copyright Act 1957 7 times amend हुआ है. कभी भी 30 सेकंड फ्री में ले लो बोल के किसी कहीं लिखा नहीं है. ये लोगों के दिमाग में घुसा हुआ है. 30 सेकंड लेके कमर्शियलाइज. The moment you are commercializing, except for the list of users exemption given in the section 52 subsection 1, आप use नहीं कर पाओगे. 30 second is a myth. Yeah. ना खत्म हो गया इसलिए उसको पता चल गया ये चोरी है. Yeah. Coming to my friend Rumpa. I know Rumpa, Sandeep ji mentioned about the earlier films they included songs, but without taking the permission. it is inclusion of song as a synchronization. Can you explain something about synchronization? How, in what way it is violation? In what way it is not violation? Please, briefly.
So Dr. Marwa mentioned one thing that like if the producer is earning from the music, then a portion of that goes to the author composer. But why the amendment happened and why music like became big? Because the music like grew bigger than the movie. Today, a lot of flop movies are also there, but the music is very popular, and we see the music being used as reels in Meta, on YouTube and other platforms. Artists are earning a lot from the music, even if the movie is not doing well. And non-film music is now growing very big. So where the sync licensing comes is that a music is made as a song. It's a song. A movie is an audiovisual content. The song was not made for the audiovisual. Now, as an independent artist, I have made a song, and that is happening. You are seeing an OTT like series producer. They see they hear the song, and they feel that it is very ideal for my for my series or for this scene.
Even for some advertisement.
Advertisement also. So then they cannot just pick up the song and put it in the movie or in the ad. Then that becomes copyright infringement. So what they have to do, they have to reach out to the right holder. So here I will just quickly explain two things. Suppose the copyright law says the creator is the first right holder of the of the creation, here the song. So as an author composer, Akshay ji will be the first right holder. But lot of times because you want to make it big, you sign off the right to a label. So there you are signing off the ownership right. But you have signed the ownership right, but the authorship right remains with the creator. That cannot be taken away. So here, if the label is owning the ownership right, so the person who wants to use the song in a like ad or in a movie has to go to the label. They have to negotiate. There is no fixed rate for a sync licensing because, like, depending on the popularity of the artist and the song, the rate can vary. You have to take a license, and then only you can incorporate that in the audiovisual, in an ad film or in a movie. If you're not doing that, then it's like outright copyright infringement. So you might question that will the author not benefit from it? Yes, they will benefit. So now when this ad is running on television or any other platform, there is another set of royalties generated for the public performance of this audiovisual. That royalty comes back to the author composer through IPRS.
Yeah, thank you, Rumpa. And I would like to thank all my panel members, Mr. Akshay, Ms. Rumpa, and Professor Alka, and Dr. Sandeep. 3 questions from audience, if you have any questions. Yeah, please.
My question is to Professor Al-Kachavi about the AI being under the Copyright Act. See, whatever you create and then you use AI over that, you cannot check, you cannot verify, because any prompt given once again will not give the same result. It is based on data. Data is dynamic. Suppose you want to check whether these prompts are given. You can't give same prompts at all. It is gone is gone. So therefore, moment AI enters, the Copyright Act will never, or it will be free for all. It will happen.
That is what I said, that there are 2 kinds of AI. When you're using AI and producing something, there's an element, human creativity involved. Then that would be copyright protected. But no, of course it is recognized. Sir, I think there is a problem in understanding what is the meaning of AI. AI is artificial intelligence, is the full form. It's any machine which is used by a human to produce something. That is one. And second is, you're giving instructions to the machine and machine is producing something. Right? I'll give, I just, the
Yeah,
the example
yeah.
that I gave you was
That is
when you use a camera, it is assisting you to make something. The output is yours. But in the second case that I talked about was the output is by the AI. No, sir. Anyway, it's. I think you should go through the evolution of the entire. I'll tell you. It's began way back in 1920 when the first automated chess system came. So from then on there has been changes which have come up.
Any other question? Yeah, please.
These days that they might be using 10 seconds of content and they get copyright strike from YouTube, the copyright holder. And this I think is a problem because their entire business is based on that, and this strike itself can negate their entire year of hard work. So how do you think, anyone can answer, that we balance the copyright strike provisions? I don't think they're even following the IT Act or the Copyright Act when issuing these strikes. YouTube itself is doing on its policy. So, but how do you think we balance creators' rights and the people who hold the copyright?
There is no creativity. So when Sandeep ji is making a film, without copying any song, without copying any scene, he is shooting the film originally and engaging a
Making your own
songwriter
content.
and author, everything originally created. But when a YouTube influencer making a video, okay, whether it is a news-based video or a film story, let us say he's explaining Durandar film, how it is written, etc. He's taking clips from Durandar and putting there, even taking a photo. Copyright Act clearly says taking a snapshot of a film made by Dr. Sandeep is infringement of copyright. There is no 10-second rule. So not only 30 second, 10 second का भी नहीं है, अलो नहीं करेंगे. मेरा कानून अलो नहीं करती है Copyright Act 10 second के लिए. Because in YouTube, when you upload, okay, or any platform, you know and a subscription model is there. मुझे बोलोगे सब्सक्राइब करो भैया, and मैं weekly 70 rupees, monthly 700 और yearly something आप पे कर रहा हूँ. YouTube का आपका शेयर है, your commercial channel है आपका YouTube channel, using the film made by, उनके कटिंग लेके दिखा रहे हो, इनका गाना दिखा रहे हो, इनका दिखा रहे हो, और 10 सेकंड बोल रहे हो. मैंने इन्फ्लुएंसर हूँ, मैंने वीडियो बना दिया, ये ANI ने बोला, ANI का न्यूज़ क्लिपिंग उसमें डाल रहे हो, without giving taking consent from them and also paying royalties to them. It was infringement of copyright. तो ये बंदा लड़का यंग सरदार जी नाम भूल गया हूँ, उन्होंने मेरा सेक्रेटरी कुछ ईमेल लिखा था. He thought, no, सेक्रेटरी साहब सीनियर अफसर हैं, उनको जल्दी हेल्प कर देंगे. वो इन्फॉर्मेशन हमारा है, तो हमने यही एडवाइस दिया, हम चुप बैठना है. Let him fight the case with ANI in the Delhi High Court. Total infringement है उनका. He is making money out of their content. इनका क्या is just giving a commentary. It is not a news and current affairs channel like NDTV or Republic or Doordarshan, where something they are explaining. Then exceptions are there for them, not for the individual is making a commercial video as a commercial YouTube channel for making money. It's not allowed.
Let me also add, even while press conference, when you actually advertise or talk about, propagate about your film, nowadays channels are very smart. They instantly take a consent letter from the producer to save themselves from probably a rainy day. So they're very conscious. People become very conscious about this copyright. So even if I'm giving a song to play on television or on radio, I have to give them a consent letter that I'm not charging money. You can comfortably play this music or show this film on television, or even a trailer, by the way, even a teaser.
And I got the information that we have already crossed the time limit. I have to wind up as the chair of this session. I would like to thank again Dr. Sandeep, Professor Chawla, and Ms. Rumpa Banerjee ji, and Mr. Akshay for their valuable contribution in this panel discussion. Again, wants to thank IPTSE and Sheetal, Purvi, and Hitashi for organizing such a great thing, and their team, in fact. And Jai Hind, Jai Bharat. Thank you.
Wonderful. Well conducted.
Of the panel for continuing the discussion.
Nearly.
Ladies and gentlemen, may I have your attention? We have a special surprise element now related to creativity in music, and Mr. Kushal Wanwa will be performing right now. everyone, can you please all be seated? We have a special performance right now. Thank you. The performance will be followed by a special lecture, by a keynote address by our chief guest, Sri Aman Sharma. Yeah. And after that, we'll have our award ceremony followed by the dinner for everybody. Thank you. Thank you. Ladies and gentlemen, we now arrive at the much awaited segment of the evening, the 8th edition IPTSE Awards Ceremony. The awards recognize students, faculty members, working professionals, and startups who have demonstrated exemplary performance in the 8th edition of IPTSE and who embody the spirit of innovation, creativity, and IP excellence. It is our honor to invite our chief guest, Shri Aman Sharma, IPOS Joint Secretary, Department of Pharmaceuticals, Ministry of Chemicals and Fertilizers, Government of India. May I request Ms. Hiteshi Trivedi to welcome. I request Dr. G.R. Raghavendra, Mr. Patrick Hopkins, Ms. Hiteshi Trivedi, Ms. Purvi Pandey to kindly be at the dais for the award ceremony. May I now request our chief guest, Shri Aman Sharma, to deliver the keynote address for our award ceremony. Whatever way you think of it.
Thank you, Hiteshi ma'am. Thank you very much for giving me an opportunity to attend this program. And I'm thankful to all the organizing team as well. Ladies and gentlemen, so I basically come from the pharmaceutical side. So of course I'm a new entrant to this sector. So but nonetheless there is some background that I do have in the pharmaceutical sector and what all issues are there with regard to the intellectual property. So the basic thing that I would basically highlight before you is that India is among the global leaders in the pharma sector, and by volume we are the third largest manufacturers of pharmaceutical products, and our strength primarily lies in the generics. So generics, I would say, that is something which is beyond the patented medicines. So whenever a patent expires, so that is where we actually step in, and the kind of strength that the country has in manufacturing of, I would say we are very good in the chemical entities, and of course we are building our strength in the biologicals also now, but chemical based entities which have gone off patent, that is what we manufacture, because we have the scale, we have the capability, and we are good at manufacturing these chemical entities at a very, very low price, I would say. And yes, more or less there are no issues in the quality. Of course, one-off cases do happen, but overall we supply to almost 194 markets worldwide, and US alone consumes 40% of the generics in US are basically of Indian origin. So we are supplying to stringent markets. We call it as SRA market, stringent regulatory authorities market. So US FDA, as we all know, it's a very, very strict organization when it comes to giving approval for drugs or food items or devices or cosmetics. And out of $30 billion worth of medicine that we supply or export worldwide, $10 billion worth is alone to US. So that basically proves our strength, both in terms of delivering at a very competitive price as well as maintaining the quality. Now, what is happening of late is that the global drugs market is moving from chemicals to biologicals now, and by biologicals I would mean the size of the molecules is growing now. So instead of chemical based entities which can be manufactured using chemical reactions, the world is shifting more towards fermentation based drugs. So you basically you have these fermenters in which either using recombinant technology, you are making the bacterial cells produce a certain drug, biological drug, or you are using eukaryotic cells also. So this is how basically it is being done. And in India also, as our population is now aging now, we are moving from that bracket of less than 35 to almost 45-50 years. So the disease load is also shifting. So we are moving away from communicable diseases to non-communicable diseases. And in non-communicable diseases, basically we are talking about diabetes, we are talking about renal diseases, we are talking about cancer. So there the chemical based entities are not the ones which will actually give you the cure. So it is the biological entities. So now biologicals are, I think, 100% with the multinational companies. We do not have any innovative products coming out of this country. And why that is not happening, the reason is primarily economic reason, because to discover one drug you need to invest almost $10 billion and almost a lead time of 8 to 10 years. So that is what is required to come out with a novel drug. And in India, the private sector, somehow they do not want to take that risk, because high risk sector, you can basically lose the whole money that you invested, because you start with the bandwidth of say 1 lakh molecules, and that you reach up to say one molecule at the end of 10 years. So this is how it is done. Of course, we have our strength in clinical trials, but as per the drug controller rules, we do not allow any novel drug to come to India which has not undergone the phase 1 clinical trials. So only after phase 1 you can come here. And yes, we do have a lot of multinational companies coming into India to conduct the phase 2 and 3 and 4 trials. So that is definitely taking place. But when we see the landscape of research in the country, so we have more cases of in-licensing and out-licensing. So what is happening is that Indian pharma companies, they do not want to go the entire, they don't want to perform the entire journey. So what they will do is they will discover a molecule, do the toxicity studies, animal trials, and maybe phase 1 trials, and sell it off to some multinational company. And that multinational company will then take it over and go through the remaining clinical trials, and they will also do the marketing, manufacturing, everything they will do. So we will basically just gather some money and get out of the game. So this is something which is happening, and not very good as far as the development of intellectual property is concerned in the pharma sector. The other thing which is happening is in licensing. Somebody has manufactured a drug, they have taken the approval of their regulator in some other country, and then the Indian pharma company will take the license to manufacture and market it in India. So basically what we are doing is we are not doing any innovation. And the reason of course cannot be purely attributed to the intellectual property landscape within the country. After 2005 we all know that we are at par with what the world is doing. So we amended the Patents Act and gone from the process patent to the products patent now. So intellectual property is fairly safeguarded in the country. Of course, we do have a provision, I think it's section 84 of the IP Act, which allows for compulsory licensing, but that only I think one case has happened as far as the pharma sector is concerned. So I really don't see any reason why we should not have innovative drugs coming into the country. And this is one area I think our industry seriously needs to look into it. Why we are not able to really invest into R&D. It's not that Indian companies don't have that wherewithal. We have very large companies, especially in the pharmaceutical side, operating in the country. They have lots of money, I know that. And but still that taking that risk to develop intellectual property, that somehow needs to come in. And when it comes to the role of the government, I think in the patents and intellectual property, I think the role of the government as far as the medical sector is concerned is pretty high, because what we have seen happening across the world is that any pharma company comes out with a patent, and here very interestingly the patents in pharma are held not by individuals, they are held by pharmaceutical companies, because it's a it needs big money. And individuals basically they develop a molecule and they sell it out to the big pharma companies. They cannot do the entire journey because it involves billions of dollars, rupees investment that individuals cannot do, of course. So what these big pharmaceutical companies and giants, I would say, they would do is they would try to do evergreening, patent ticketing, so that the life of a patent is 20 years worldwide. But they want it to continue for 30, 40, 50 years. And we have seen a number of instances where blockbuster drugs are like they are protected so fiercely by a web of patents that nobody can actually get to manufacture them and market them. So this is something where the government needs to step in, because I don't think it's a good idea to give such exclusive marketing rights to a company for 30, 40, 50 years. Ultimately, whenever a drug goes off patent, the generics have to come in, and in biologicals we call them as biosimilars. So as we all move towards the biologicals, and we should not in fact it's the role of the government to basically ensure that biosimilars do come in. And because whatever money you've invested, primarily if you invest $10 billion, the blockbuster drug will give you $200-300 billion. So I think there's enough of profit for any company to basically move ahead, and it's an incentive also for them to keep on putting money into the research. But yes, there has to be a limit to profit making, and that is where I think the role of the governments becomes important. US also has similar problems, so they keep on taking suitable action on it. So same is the case in India, and but if of course the role of the government here has been pretty, I would say, on the lower side, because not much innovation is coming in. So once we also join that league where our companies start putting money into innovation, I think there we'll have lots to do. So that is all I have to share with all of you. So this is what I all knew about intellectual property as far as the pharma sector is concerned. Of course, intellectual property doesn't limit only to pharma. There are, I think, almost all the sectors are relevant and important as far as safeguarding and promoting intellectual property is concerned. So I'm sure you must have done a lot of deliberation on the various other sectors as well. So I wish all of you good luck in your journey forwards, and thank you, ma'am. So keep doing great work. Thank you very much.
Thank you, sir.
Thank you, sir, for your inspiring words and encouragement to the IP talent community. We now proceed with the felicitation of awardees. I request the dignitaries Shri Aman Sharma, Dr. G.R. Raghavendra, Mr. Patrick Hopkins, Ms. Hiteshi Trivedi and Purvi Pandey to kindly present the awards as we call upon the recipients category-wise. In the school category, we have Aditya Bhandari, New Greenfield School, AIR 1. Can we have a round of applause for him? Next upon we have Dhruv Dhandekar, Ryan International, AIR 2. In the university category, we have Yash Raj, Lingus Vidyapeeth, AIR 1. Can we have the round of applause, please? Thank you. Next upon we have Vipin Khandil's Satyavati College, AIR 2. Next upon we have Lakshay Bharve, Acropolis Institute of Pharmaceutical and Engineering Research, AIR 3. Can we have the round of applause, please? Thank you. In the next category is the working professional category. Mr. Abhinav Singh Kendrill, working professional AIR 1. Yeah. In the next category, we have the faculty category, Ms. Ankita Dubey, Acropolis Institute of Pharmaceutical and Engineering Research, faculty AIR 1. A round of applause, please, ladies and gentlemen. Thank you. Next, we have the award winners for domain winners under the law with IP, Mr. Mohak Jotwani, Siddhi Raghuvanshi, Aman Farooq, Yashraj Patel, Kishnu Bellor, and Savan Seth. Okay, Mohak Jotwani, law with IP, Siddhi Raghuvanshi, hospitality industry, Aman Farooq, Siddhi Raghuvanshi, hospitality industry. Aman Farooq, research and science. A round of applause, please. Thank you. Yashraj Patel, media and communication. Kishnu Bellor, design and architecture. And Savan Seth, pharmaceutical and IPR. Now for the startup category, we have Yash Tokas, 3N Legal Services, Startup AIR 1. And now for the best institute category, the winner is Acropolis Institute of Pharmaceutical and Engineering Research, AIR 1. The award will be collected by Ankita Dubey. Ladies and gentlemen, this brings us to the conclusion of the formal proceeding of the 8th edition IP Conclave and IPTSE Awards. On behalf of IPTSE, we thank you for being a part of this enriching dialogue on intellectual property, collaboration, and creativity. You are warmly invited to join us for networking and dinner starting very shortly. Have a wonderful evening ahead. Thank you.
You will not spare us. Thank you, sir. Sir, अपना shawl और you need a bag. I just get a bag. For the shawl.
Ladies and gentlemen, the dinner will start at 8. Till then, please feel free to network and mingle. Thank you.
Isn't she?